The Royal Commission into Violence, Abuse, Neglect and Exploitation of People with Disability is now in session.
Good morning, everybody. I welcome everybody who is or will be following this, which is the Commission's 19th public hearing. The subject of this public hearing is measures taken by employers and regulators to respond to the systemic barriers to open employment for people with disability. I commence by acknowledging the Gadigal people of the Eora Nation, on whose traditional lands Commissioner Ryan and I are sitting. I also acknowledge the Wurundjeri people of the Kulin Nation, upon whose lands Commissioner Galbally is sitting for the purposes of this hearing. I pay our respects to their elders, past, present and emerging. I also pay our respects to all First Nations people who are participating in or following this hearing. This hearing was originally scheduled to take place in Melbourne in July of this year. Because of the significant COVID-19 outbreaks and the restrictions that have been imposed along the eastern states of Australia over the past 5 months, we have had to postpone and, in a sense, relocate the hearing. We're not yet able to hold a public hearing at which witnesses appear in person in the hearing room, and nor can we as yet have members of the public attend the hearing. But we do hope that our first hearing in 2022 will mark a return to a public hearing of the Royal Commission in the fullest sense. For this hearing, as I've already indicated, I'm joined by Commissioner John Ryan AM in the Sydney hearing room. Commissioner Rhonda Galbally AC is participating in the hearing from Melbourne. Senior Counsel assisting the Royal Commission, Kate Eastman SC AM, is also in the Sydney hearing room, together with Ms. Elizabeth Bennett SC and Ms. Kathy Dowsett. We take the opportunity of congratulating Ms. Bennett on her elevation to Senior Counsel. All witnesses, and I understand there will be approximately 40, will give evidence remotely, thereby presenting more than the usual IT challenges. A large number of parties have been given leave to appear at the hearing. Their legal representatives will also appear remotely. I'll take the appearances at the conclusion of these opening remarks. This public hearing is the sequel to Public Hearing 9, which was held from the 7th to the 11th of December 2020. At that hearing, the evidence addressed the barriers to economic participation by people with disability in Australia from the perspective of people with disability themselves, including people with disability seeking employment or already in employment or who have experienced employment. Public Hearing 9, like all our hearings, including this one, was conducted within the human rights framework created by the Convention on the Rights of Persons with Disabilities, the CRPD. A number of the articles in the CRPD are particularly relevant to today's hearing. The most significant for present purposes are Article 3, which states general principles, Article 5, which deals with equality and non-discrimination, and Article 27, which deals with work and employment. The general principles stated in Article 3 include respect for inherent dignity and individual autonomy, non-discrimination, full and effective inclusion in society, and equality of opportunity. Article 5 requires state parties such as Australia, quote, to prohibit all discrimination on the basis of disability and guarantee to persons with disability equal and effective protection against discrimination on all grounds. In order to promote equality and eliminate discrimination, states parties are required by Article 5, subparagraph 2, to take all appropriate steps to ensure that reasonable accommodation is provided. We have heard at other hearings about the notion of reasonable accommodation. Article 27 obliges state parties, such as Australia, to recognise the right of persons with disabilities to work on an equal basis with others. This right includes the opportunity to gain a living by work freely chosen in a labour market and in a work environment that is open, inclusive and accessible to persons with disabilities. State parties are also obliged to safeguard the right to work by taking, among other measures, appropriate steps to prohibit discrimination on the basis of disability with regard to all matters concerning all forms of employment. Let me say something about the evidence at Public Hearing 9. The evidence at Public Hearing 9 included data relating to the respective workforce participation rates of people with disability and people without disability. We also heard powerful evidence from numerous people with lived experience of disability about their attempts to gain employment and what happened to them when they did secure employment. We heard that Australia has one of the lowest employment rates for people with disability in the OECD, and that there has been little progress to improve the rate of employment for people with disability in Australia over the last 25 years. The Australian Institute of Health and Welfare has documented that people with disability not only experience higher rates of unemployment, but tend to remain unemployed for considerably longer and, importantly, experience much higher rates of underemployment than the general Australian population. Expert evidence that we heard at Public Hearing 9 suggested that the pool of unemployed and underemployed people with disability in Australia is very much greater than the official figures might suggest. We also heard at that hearing that according to a study by the Australian Human Rights Commission, nearly half of people with disability in employment experienced discrimination or unfair treatment by their employers during the previous year. During Public Hearing 9, people with disability told the Royal Commission of their strong, even passionate desire to obtain work and to flourish in employment. They emphasised, as one would expect, the personal fulfilment to be gained from paid employment, the satisfaction of contributing to the Australian economy, and also the satisfaction of making their entitlement to be accepted as an equal member of Australian society much closer to practical reality. We also heard about the profoundly demoralising consequences when people with disability are repeatedly rejected by prospective employers for reasons connected with their disability. People with disability gave evidence that they had experienced discrimination by employers or prospective employers reflecting bias, conscious or unconscious, against them, misconceptions by employers or human resources staff about the capacity of people with disability to fulfil the requirements of a particular job, employers assuming wrongly that people with disability create risks to health and safety for which employers may be made liable in some sort of proceedings, and employers failing to understand their legal responsibilities towards people with disability, in particular, that discrimination on the ground of disability occurs when an employer does not make or proposes not to make reasonable adjustments for the person with disability. The hearing heard evidence about the barriers to employment participation in the labour force of people with disability. At the hearing, 4 categories of barriers to economic participation of people with disability were identified. Ms. Eastman will say more about this. I will note that the 4 categories are attitudinal, that is, biased assumptions made by prospective employers about the capacity of people with disability to do the job; environmental, such as the physical inaccessibility of premises and the absence of accessible technologies or workplace environments; organisational, such as the lack of assistance or reasonable adjustments to allow for a smooth transition into the labour force, into employment; and structural, such as the lack of integration between income support programs and the labour market for people with disability. As the Secretary of the ACTU, who has provided a statement to this hearing, points out, these barriers, of course, interact with each other. They should not be seen as entirely separate from each other. We shall hear evidence today from Mr. Graham Innes AM, the former Australian Disability Discrimination Commissioner. Mr. Innes will tell us of the struggles he had early in his career to secure employment despite his legal qualifications. He also expresses the view that he has yet to observe the creation and implementation of a policy that has had a significant impact on the, in his words, abysmal labour force participation rate of people with disability. Mr. Innes, who has vast experience in this field, considers that the barriers to labour force participation were accurately identified in Public Hearing 9, and he uses that as a framework for his statement. The statement from Ms. Kirsty Wilson, who is the Principal Legal Practitioner and CEO of Association of Employees with a Disability Legal Centre, also adopts the 4 barriers as the framework for her statement. That statement draws on her extensive experience as a human rights and industrial lawyer. The present hearing will address how the barriers that have been identified can be broken down and the role employers in both the private and public sectors can and should play in removing those barriers. It's also important to point out that at Public Hearing 9, we heard evidence that some employers, with the active involvement of a number of organisations, had made strenuous efforts to understand the challenges, had introduced innovative programs and policies that were designed to break down the barriers facing people with disability in securing employment. These provided illustrations of good practice that deserve acknowledgement and warrant emulation. Let me now address some other sources of information that inform this hearing. Public Hearing 9 is not the only source of material that informs the content of this hearing and the policy issues with which the Royal Commission will have to grapple. We published an employment issues paper in May 2020, asking questions about barriers faced by people with disability in entering or remaining in the labour force. We received 65 responses. They included large private sector employers such as the NAB, the Commonwealth Bank and Telstra, public sector employers such as the Commonwealth Government and state governments, Commonwealth, state and territory statutory agencies, employers who might be regarded as on the borderline of public and private sectors like universities, employment service providers and business advisory bodies. We published an overview of these responses in March 2021. That overview is available on our website. The responses provided significant information on employment practices, and many made constructive proposals to improve labour force participation rates by people with disability. Perhaps most importantly, they demonstrate that at least some of this country's largest employers are aware that our employment policies and practices have largely failed people with disability, and that the responsibility for correcting and addressing the errors of the past rests not only with governments, but with all employers. In April 2020, we published the Rights and Attitudes Issues paper, asking questions about community understanding of disability and the attitudes and behaviour exhibited by people without disability towards people with disability. We received 66 responses to this issues paper from people with disability, disability representative organisations, governments, statutory bodies, professional bodies, disability service providers and academic researchers. The overview of responses to that issues paper is also available on the Royal Commission's website. The responses indicate that many people without disability, including many employers, have a limited understanding of the concept of disability. The responses also suggest that non-disabled people in the Australian community tend to have negative attitudes towards people with disability. Perceptions are often based on stereotypes. In the people with disability are perceived to be a burden on society or their families, incapable of making their own decisions or performing jobs, even those for which they have qualifications, or perhaps less intelligent or skilled than other people, regardless of the nature of their disability. This hearing, in a sense, represents the intersection between the responses to these two papers. We are examining the practical consequences of barriers to people with disability participating in the labour force, and what employers, and particularly large employers, can do and should do to correct a situation which cannot be allowed to continue unaltered. We're also examining the attitudes or the impact that community attitudes have in shaping the relationship between people with disability and the labour market. The four barriers that I referred to earlier are the product of bias against and misconceptions about people with disability. This is also known as ableism. When we talk about a human rights approach to the matters within the Royal Commission's terms of reference, the tendency is to focus upon the interpretation of particular articles and the extent to which the Australian government has conformed to its obligations under international law to implement the articles. But as Public Hearing 9 and this public hearing will demonstrate, the Australian government is not the only body with the power, responsibility and resources to bring the aspirations stated in the CRPD closer to realisation. The entities with the power, responsibility and resources include employers, both in the private and public sector. The Article 27 right to work on an equal basis will remain a largely empty promise or aspiration unless employers, especially large private and public sector entities, play their part in giving practical effect to the rights and aspirations articulated in the CRPD. All employers, of course, need to understand and fully comply with their legal obligations under domestic legislation, such as the Disability Discrimination Act 1992 of the Commonwealth. But data to which Ms Eastman will refer shows that employers must introduce additional measures to increase the workforce participation rates of people with disability. This is not merely because the CRPD recognises the right to work as a human right. It is also because, in stark economic terms, people with disability, as was discussed at Public Hearing 9, constitute an underutilised national asset. There are large numbers of people who are willing and able to work productively, but are prevented from doing so by community attitudes and employment practices that in many respects belong to another age. It follows from what I've said that it's not enough to focus on whether the Australian government has sought to advance the broad objectives stated in the CRPD, nor is it enough to rely on the enforcement of domestic laws to afford people with disability the fullest possible opportunity to participate in the economic life of the country, and thus bring about, as our terms of reference envisage, a more inclusive society that protects people with disability from violence, abuse, neglect or exploitation. If these changes are to occur, community attitudes towards people with disability need to change. As we know, attitudinal and cultural changes are driven by a range of forces. They include bringing to light cases that show the devastating consequences of discrimination, leading to violence, neglect, abuse and exploitation. But changes in community attitudes and practices are very difficult to achieve unless those changes are driven by community leaders. And so it is with employers. They, especially the large employers, have a responsibility to lead the way, not just by adhering to their legal duties, but by promoting attitudinal and cultural changes within their organisations and in the wider community. In short, we all share the responsibility.
Thank you, Chair. Are you going to take the appearances now?
Yes, we'll take the appearances, thank you. I think we're going to do it in a streamlined fashion, as I understand.
So I might start. So I appear as Counsel Assisting the Royal Commission with Ms Bennett SC and Ms Dowsett. Thank you.
Thank you. I think there is a document, is there not, that lists the representatives. In fact, there is a document, it's right here. Perhaps the easiest thing, rather than attempt to do this by going around to many different sites, if I indicate the appearances, and if I've got anything wrong, somebody will tell me. For the Commonwealth of Australia, the appearances by Mr. Hodge QC with Mr. Dighton, and they are instructed by Gilbert and Tobin. For the state of New South Wales, the counsel is Ms. Furness SC with Mr. Glover, and they are instructed by the Crown Solicitor's Office. For the state of Queensland, Ms. McMillan QC appears, instructed by Crown Law Queensland. For Mr. Olivieri, the counsel appearing is Mr. Fitzgerald, instructed by Doog and George solicitors. Kmart, the appearance is through Mr. Woods and instructed by Gilbert and Tobin. I understand that Australia Post will appear by solicitors, but they can announce their appearance when they are present at the hearing. IBM, the solicitors are Jones Day, and I understand that we will be advised of the name of counsel appearing in due course. Lend-Lease Australia appears through Ms. Hugh, instructed by Herbert Smith Freehills. Medibank is represented by King and Wood Mellison solicitors. The National Australia Bank is represented also by King and Wood Mellison solicitors. The Royal Melbourne Institute of Technology are represented by Cause Chambers Westgarth solicitors. Telstra is represented by Seyfarth Shaw Australia solicitors. Woolworths Group Limited is represented by Ashurst solicitors. The state of Victoria appears through Mr. Young QC and instructed by Minter Ellison. WorkSafe Victoria appears through Ms. Harris QC, instructed by Minter Ellison also. If I've made any mistake or there needs to be a correction to that, perhaps counsel or legal representatives appearing could tell me now. If not, I'll assume that I managed to get that more or less right. Thank you.
Thank you, Commissioners. We also acknowledge and pay our respects to the traditional custodians on the lands on which we're meeting today. We pay our respects to First Nations elders past, present, and also to all First Nations people following this public hearing. Commissioners, in December last year, you convened Public Hearing 9. The public hearing was led by people with disability who shared their experience about the barriers and pathways to open employment. You listened to the evidence of 35 witnesses, including people with disability, parents, supporters, and advocates, together with some academics. You heard about the experience of people with disability finding and keeping jobs. You also heard about the transition in and out of the workforce and their experience of discrimination and exploitation. Commissioners, one of the witnesses was Oliver Collins. He lived with a very rare neuromuscular condition. In February 2020, he was one of the founding members of the diverse ability networks of the Queensland Law Society. The network was established to promote greater participation from people with disability in the legal profession in Queensland. At the time he gave evidence at Public Hearing 9, he was a solicitor in the dispute resolution group at King and Wood Mallisons in Brisbane. Mr. Collins told you about his various jobs and his career, but he spoke candidly about his personal experiences and expectations. And I want to quote a little part of his evidence. He said this: "I do not want anything to be different for me. In that, I did not want to stand out from a negative point of view because of my disability and wanted to be treated like everyone else. So I did not ask for anything. This helped me feel like I was making an equal contribution to the firm, and I was not increasing the burden on them in having me as an employee. If I'm honest with myself, this put much greater pressure on me physically as I worked through the pain and discomfort in order to achieve this. Those with disabilities should not be made to feel as if by requiring special adjustments or equipment, their contribution in a workplace would be devalued, or their contribution would be worthless in any way than an able-bodied colleague because of the differing physical disabilities. Commissioners, you'll recall that it was candid evidence. In April this year, Mr. Collins passed away. We know his passing was a great loss for his family, and on behalf of the Royal Commission, we express our condolences to Oliver's family and his colleagues at work. We greatly appreciated Oliver's participation in the public hearing, and his evidence was relevant to the matters that we will consider this week with respect to attitudes and ableism. We thank you, Oliver Collins. Well, Commissioners, you heard oral evidence in respect to Public Hearing 9 in March this year. And at that hearing, we submitted that there were recurring and common barriers to the employment for people with disability. And these barriers may be grouped into 4 broad areas: attitudinal barriers, physical environmental barriers, organisational and structural barriers. And Chair, you've touched on these barriers in your opening remarks. These barriers impair a person's enjoyment of human rights, of which the right to work is recognised as a core economic and social right. For some people with disabilities, these barriers result in violence, abuse, neglect, and exploitation. We concluded Public Hearing 9 by proposing a further hearing to provide you, the Commissioners, with the opportunity to hear from the private and public sector employers, from governments and other key bodies involved in the regulation of labour force markets in Australia. We suggested the Royal Commission may wish to inquire how employers and governments have addressed the systemic barriers we have identified. This would require an examination of the practices, policies and regulation of both the public and private sector employers, as well as governments and institutions responsible for regulating the labour market. We suggested the intended purpose of a further public hearing could be twofold. First, to explore what the employers and other key actors in this area are doing or not doing to address the systemic barriers identified in this hearing. Secondly, to explore potential measures to eliminate the barriers to open employment that cause or contribute to violence, abuse, neglect and exploitation of people with disability. So this is the purpose of this public hearing. The focus will be on private and public sector employers. This means that there will only be a few witnesses with disability participating in this hearing to tell you about their personal experiences of finding and retaining employment. So addressing the systemic barriers will not require you, Commissioners, to identify anything new. In fact, the issue is what should be done rather than, the issue is not what should be done, but the issue really is why hasn't what we already know been done. To put it another way, there has been a lot of talking the talk, and at this hearing, we will ask if there has been any walking the walk. Previous inquiries and reports have identified and considered what needs to be done. These reports have also made recommendations. And Commissioners, you should ask, why have the recommendations of past reports been ignored or failed? In March 2007, the Australian Safety and Compensation Council published a report called "Are People with Disability a Risk at Work? A review of the evidence." In March 2007, the findings were as follows. First, contrary to a common perception of increased occupational health and safety risk for people with disability, a national study of employers in Australia found that workers with disability have lower number of occupational health and safety incidents compared to average employees. Secondly, with respect to workers' compensation costs and occupational health and safety costs for employers, employees with disability are much lower compared to the average employee. Thirdly, the productivity of employees with disability is similar to that of employers without a disability. Employees with disability are longer serving and have less turnover. The report found that the actual cost of making workplace accommodations was quite low, and the economic benefits of employing people with disability exceeded the costs of those accommodations. The accommodations reported in the literature related to access, but not accommodations related to safety. And a third to half of people with disability requiring accommodation were not receiving the accommodations. And this was despite anti-discrimination legislation that required employers to make reasonable accommodation for people with disability. 2 years later, in 2009, the data available told us that 54.8% of people with disability of working age, being people between the age of 15 and 64, were employed. In 2009, the National People with Disability and Carer Council, on behalf of the Australian Government, published its report, Shut Out: The Experience of People with Disabilities and Their Families in Australia. This report found that employer attitudes posed the biggest barrier. And in 2009, the following matters were identified. First, entrenched discrimination and misconceptions about the adjustments required for some people with disabilities. Secondly, that the cost of making workplace adjustments was often overestimated and based on inaccurate estimates of the costs. Thirdly, other qualified candidates for jobs were screened out or simply overlooked because of their disability. And concerns were raised about practices involving mandatory medical assessments being used in a way to screen out candidates with disability. Next, occupational health and safety requirements were also sometimes used as an excuse for both refusing and restricting employment opportunities. But at the same time, there was confusion about the nature and extent of those obligations. The National Disability Strategy 2010 to 2020 noted that a vast majority of people with disability can and do want to work, and they wish to be financially independent as far as possible. In 2011, in a report commissioned by the Australian Disability Network, Deloitte Access Economic undertook economic modelling that found that Australia will forego substantial economic benefits if labour market disadvantages faced by people with disability are not addressed. The modelling showed that if the gap between the participation rate and unemployment rate for people with and without disability could be reduced by just 1/3, phased in and up to the present year, 2021, the cumulative impact on GDP would be in the order of $43 billion. The modelling showed the economic benefits for increasing labour force participation of people with disability could be significant. In 2014, the Australian Chamber of Commerce and Industry issued its report, Employ Outside the Box: The Business Case for Employing People with Disability. And perhaps unsurprisingly, it found that if the business community does not take action now, that's back in 2014, all businesses will be threatened in future years by increasing costs of labour. That report addressed the myths and stereotypes around employing people with disability, and it included some practical suggestions for addressing recruitment, practices, support, and the evaluation. Then, in October 2015, the Business Council of Australia released its report recognising ability, business and the employment of people with disability. The BCA undertook a survey of its members with respect to the approaches of business to the employment of people with disability. It found this: boosting the active participation of people with disability will deliver individual, social and economic returns. Then, as the Chair has noted this morning, in May 2016, the Australian Human Rights Commission published the Willing to Work report. The Willing to Work report found that employers, businesses, and organisations that represent them have a critical role to play in recruiting, retaining, training people with disability. And it also noted the importance of there not being a one-size-fits-all approach. The Willing to Work report made some overarching recommendations to address systemic issues related to the employment of people with disability. Notwithstanding the Willing to Work report and subsequent reports and inquiries, there appears to be little improvement. So, Commissioners, may I remind you of some of the available data concerning people with disability and employment in Australia. The most recent data is 2018. That data tells us that 4.4 million Australians with disability represent 17.7% of the Australian population. Of that group, there were 2.1 million people with disability who were of working age, that is, between 15 and 64. The labour force participation for that group was 53.4%. That is lower than 2009. And it stood in contrast to an increase in the participation rate for people without disability, then in 2018 being 84.1%. The labour force participation rate was 38% among the people of working age who live with autism spectrum disorders. And the unemployment rate for people with autism spectrum disorders was 34%, more than 3 times the rate for people with disability and almost 8 times the rate for people without disability. In the preparation of this hearing, we asked the Australian Government why the rate of employment for people with disability has not improved. Their answer was to refer us to the various reports, including Willing to Work. So, Commissioners, we must ask why the investment in various strategies and initiatives have not succeeded and whether a different approach is now required. One of those questions will be to ask if taking a human rights approach might make a difference. This is an approach that takes into account the Convention on the Rights of Persons with Disabilities. And Commissioners, you heard at the recent Public Hearing 18 that there are a range of initiatives concerning the employment of people with disability, including the work done by the International Labour Organization and the approach described in the UN Guidelines on Business and Human Rights. So we ask whether those approaches could make a difference. Commissioners, tomorrow you'll hear from the Australian Council of Trade Unions about its recently adopted Workers with Disability policy. The policy acknowledges unemployment, sub-minimum wages, insecure work, discrimination, violence, harassment, and minimal retirement to lead to high rates of poverty. These are matters that are entrenched and systemic for working people with disability. The ACTU's policy identifies a range of areas for improvement, from worker representation, wage fixing tools, flexible working arrangements, superannuation, insurance, and broader supports. You will also hear from the Business Council of Australia. Ms. Jennifer Westacott, the CEO, will tell you that the Australian economy has undergone unprecedented periods of sustained growth for almost 30 years. But despite the overall strength of the labour market, policies, legislation, and a raft of government programs, the labour force participation of people with disability has fallen behind the rest of the population. She says there is a compelling economic case for increasing labour force participation for people with disability. Now, Commissioners, over the next 5 days, you will hear from 12 of Australia's leading companies. Indeed, they are iconic brands. You'll hear about their recruitment practices, policies, and how they approach workplace adjustments for employees with disability. We will examine whether their recruitment and employment practices are accessible for people with disability. What actions are they taking to provide accessible, safe and inclusive workplaces for employees with disability? But obviously 12 employers is a small snapshot of all Australian employers. However, based on the information provided to the Royal Commission, these 12 companies employ over 485,000 people. We asked each of the companies to tell us how many employees with disability are recorded in their employment records, in their HR systems. And taking these companies together, only about 1.15% of all of their employees identified as people with disability. I'm going to show you now a table which breaks down the rates of employment for our large Australian employers. Commissioners, you will see that the lowest rate identified in the 12 employers that we identified was IBM. You'll see out of a total of 3,110 employees, only 5 people with disability was recorded in the human resources system. That constitutes 0.16% of employees at IBM who identify as people with disability. You'll see that we've tracked through organisations such as Lendlease. It records 0.17%. RMIT has employees in the order of 7,700. It employs 22 people with disability, 0.29%. Medibank, 0.46%. Kmart, 0.5%. Accenture, 0.74%. Woolworths, which is the largest employer among this group, employing over 200,000 Australians, has 1,705 people with disability recorded in its HR system, constituting 0.85%. Telstra, another large employer in Australia, close to 1% at 0.99%. 2 of these employers make it over the 1% mark, the Compass Group at 1.90% and Australia Post at 3.91%. Commissioners, we also asked McDonald's and the National Australia Bank. McDonald's collectively, through its own organisation and its franchisees, employs over 110,000 people, but its HR system did not record the number of people with disability, and the same for the National Australia Bank. So the rates of employment among some of our large and iconic employer and brands in Australia is disturbingly low. Now, the employers will tell you over the course of this hearing is that these numbers might change if we look, for example, at the surveys that are done in workplaces or the census that might be undertaken. And we accept, and we will explore during the course of this hearing, that when people are asked to disclose whether they have a disability on an anonymous basis, the numbers tend to be higher. But collectively, looking at all of this information, none of these brands exceed 5%. Commissioners, the data is a key issue, likewise record keeping. There is a lack of a consistent approach among the Australian employers to recording and tracking data with respect to the employees with disability. Commissioners, though, you will be aware of the Workplace Gender Equality Act, a piece of Commonwealth legislation that deals with the collection and publication of data that identifies trends relevant to the participation of women in the labour force. Non-public sector employers with 100 or more employees must report annually against 6 gender equality indicators. But there is no equivalent requirement in Australia for reporting for employees with disability or any disability equality indicators. So the absence of mandatory reporting requirements for disability means that there is limited, patchy and unreliable data. It's not just the private sector. This week, you will hear from the Public Service Commissioners from the Australian Government, Victorian Government, and the Government of the Northern Territory about what the public sector is doing to attract, retain, and promote employment for people with disability. It is beyond the scope of this hearing to address the data and policies and indeed practices of each and every Australian state and territory. So by reference to the three governments, we will examine how the public sector approaches recruitment, their practices with respect to making workplaces accessible for people with disability, and what actions are taken to provide a safe and inclusive workplace. We'll also examine important employment concepts such as inherent requirements of the job and the approach to making reasonable adjustments. So let me tell you what the data tells us in relation to the employment rates of people in the public sector. And I'll put up a small graphic on this. With respect to the Australian Public Service, the numbers of people with disability recorded in the HR system is 4%. For the Northern Territory, it is 1.2%. And for the Victorian Public Service, it is 0.4%. Now, Commissioners, I give you this data with a cautionary note, and that is that each of the Public Services Commissioners will talk to the way in which data is collected. And particularly for Victoria, the collection of data during the last year with respect to the impact of COVID-19 and lockdowns and the response rate to various surveys means that we have to treat the numbers that I've given you with respect to Victoria with some degree of caution. But Commissioners, the ideal from targets set by the Commonwealth Public Service was to achieve 7% of employment with people with disability in the Australian Public Service in the period 2020 to 2025. There's a long way to go to reach that 7% target before 2025. So Commissioners, I'll now turn to how we'll conduct the hearing over the next 5 days. This morning, you will hear from Graham Innes, AM, the former Disability Discrimination Commissioner. He will tell you about his career and his experiences seeking employment. We asked him to address a range of matters that are likely to be key themes and indeed recurrent themes arising in this hearing. He will address what needs to be done to increase labour force participation for people with disability. Then you'll hear from Robin Banks. She is the former Tasmanian Anti-Discrimination Commissioner, and she will tell you about her experience working with Australian laws and processes for addressing disability discrimination in employment. Later today, you will hear from Peter Oliveri and a panel of experienced lawyers from AED Legal and the Victorian Legal Aid. They all work on the front line. They provide advice and representation to people with disability. Mr. Oliveri is a client of one of the services, and he'll tell you about his experience in addressing disability discrimination at work. Later this week, you will hear from Sandra Parker, PSN. She is the Fair Work Ombudsman. We'll ask her about the responsibilities of the Ombudsman under the Fair Work Act and the protections available for workers with disability, such as Mr. Oliveri. You will also hear from Emily Howie and Lauren Matthews. They represent the Victorian Equal Opportunity and Human Rights Commission, and they'll also tell you about the rights and remedies available under the Victorian Equal Opportunity Act. Commissioners, the evidence over the course of this week is likely to expose the need for better education and awareness about the rights of people with disability in the workplace. It will expose the need for practical guidance for employees with disability about how to exercise those rights. It will expose the need for practical guidance for employers to comply with their obligations, and also what to do in circumstances where there may be no adjustments that can be made, or there is a perceived or real clash of legal obligations such as work health and safety and non-discrimination. And there's also a need for practical tools for building, maintaining and committing to inclusive workplaces that come from and are led by people with disability. Our final session today will be an opportunity to hear about some practices that have worked. And Ms. Christy Marcella from the Aboriginal Employment Strategy will specifically touch on what needs to be done to increase meaningful and sustainable employment. I have mentioned earlier that you will hear from the peak union and business organisations. Tomorrow, Scott Conley, the Assistant Secretary of the ACTU, will appear, and he will tell you that one of the objectives of the ACTU is to take all appropriate measures necessary to ensure secure jobs and income in decent employment. This includes protection from unfair treatment. You'll be joined by Melissa Donnelly. She is the National Secretary of the Community and Public Sector Union, which is the major union for workers in the Australian Public Service, the ACT and the Northern Territory Public Services. Together, they will address a range of issues concerning the protection of worker rights, the experience of workers in the public sector, the development of government policies, and why past initiatives have failed to meet their objectives. You will also hear from the Business Council of Australia tomorrow and some specific initiatives focused on increasing labour force participation for people with disability. Commissioners will then turn our attention to the private sector employers who I've mentioned earlier. Tomorrow and on Wednesday, there will be a number of panels focusing on the recruitment practices and approaches to making workplace adjustments. You will hear from representatives from Kmart, Woolworths, Compass, IBM, Telstra, McDonald's, the National Australia Bank, Accenture and RMIT. On the issue of workplace adjustments, you'll also hear how the public sector approaches these issues. And you'll hear evidence from the Australian Taxation Office, the National Disability Insurance Agency and the Department of Social Services. On Wednesday, we will examine work health and safety in the workplaces in Australia. Employers must manage risk to the health and safety of workers, customers, visitors and suppliers. There are comprehensive work health and safety laws in Australia to address workplace risk and to prevent death and injury, and that includes workers with disability. Employers who fail to provide safe workplaces and breach the work health and safety laws can be open to prosecution. Now, related to work health and safety is a requirement for employers to have workers' compensation insurance. For persons who acquire a disability in the course of their employment, we want to understand the support for rehabilitation and returning to work, and whether indeed the approach to the treatment of workers who acquire a disability has been different. You will hear from Lend-Lease and Australia Post as employers with respect to their response to work health and safety. But you'll also hear from the Commonwealth and Victorian agencies responsible for developing policy and regulating work health and safety in workplaces. We want to understand whether and how these regulators have addressed disability issues and specifically addressed the health and safety of workers with disability. On Friday, you will hear from the Department of Social Services and the NDIA about the Australian Government's overarching strategy. And we also, in the context of looking at strategies, want to consider a way forward. You will hear from representatives from Telstra, Medibank and Australia Post about their experience in building an inclusive workplace culture, and we'll examine what specific actions employers should or could be taking to employ, retain and promote people with disability. You will also hear from Ms. Christina Ryan from the Disability Leadership Institute. Ms Ryan gave evidence at the recent public hearing concerning the Convention on the Rights of Persons with Disabilities, and she'll build on her evidence from that hearing to focus on what needs to happen in Australian workplaces to prevent people with disability experiencing violence, abuse, neglect, and exploitation in employment. Now, Commissioners, as always, there may be information and evidence presented at this hearing that some people may find distressing, and I'll just put up now the slide with the relevant contact numbers. While that slide is up, I also remind those following this proceeding of the provisions in the Royal Commissions Act that have the clear object of protecting witnesses who give evidence before the Royal Commission. I particularly want to draw attention to Section 6 capital M of the Act. It provides any person who uses, causes or inflicts any violence, punishment, damage, loss or disadvantage to any person on account of that person having appeared as a witness before the Royal Commission, given evidence before the Royal Commission, or producing a document to the Royal Commission, commits an indictable offence. The maximum penalty for committing such an offence is imprisonment. Thank you, Commissioners. I think we're at the point of adjourning now for morning tea and return with Mr Innes.
Thank you, Ms Eastman. It's now 11 a.m. Eastern Summer Time. We'll adjourn until 11:15 and we'll resume with Dr. Innes. Thank you. The Royal Commission is adjourned. Is resumed. Yes, Ms Bent.
Commissioners, before I ask that Mr Innes be called, could I please tender exhibit the private sector and public sector employment data that was displayed in Ms Eastman's opening? I ask that that be marked as Exhibit 19-0.
Yes, now by data you mean the two
graphics that were brought up on the screen.
Shown on the screen.
Yes,
so they will together become Exhibit 19-0.
Thank you, Chair.
Thank you.
I now ask that Mr Graham Innes AM be called.
We're just waiting for Mr Innes to come on screen. Good morning. Can you hear us? Probably not. Currently not.
Yes, Chair, I can. Thank you.
Yes, thank you very much. I'm not sure, is it Mr Innes or Dr Innes? There seem to be two mechanisms.
Well, either is fine, really, Chair. I'm pretty relaxed.
All right, in that case, I'll leave it to Ms Bennett. But thank you very much for coming to give evidence today. We appreciate your assistance, and of course we have read your statement. Thank you very much.
Yes, Ms Bennett.
Ms Bennett will now ask you some questions. Perhaps I should just explain, in case you're not aware, Commissioner Galbally is in Melbourne, joining the hearing from Melbourne, and I am in the Sydney hearing room together with Commissioner Ryan. Ms Bennett is also with us in the Sydney hearing room.
Thank you, Chair. I was at your introductory comments, so I was aware of that, but thank you for letting me know.
Thank you very much. Yes, Ms Bennett.
Thank you, Chair. Mr Innes, you've made a statement dated 30 June to assist this Royal Commission, is that right?
Yes, it is.
And are the contents of that statement true and correct?
Yes, they are.
Thank you. And Commissioners, you'll find that statement at Bundle A, tab 45, with an attachment at tab 46. Now, Mr Innes, you were the chair of the Commonwealth Disability Advisory Council of Australia during the drafting of the Disability Discrimination Act from 1991, is that right?
Yes, that's correct. It was the main function of the council while I was chair. We really focused on development of that legislation.
And you were then the Disability Discrimination Commissioner between 2005 and 2014, is that right?
Yes, that's correct.
And you were also involved in the drafting the UN Convention on the Rights of Persons with Disability, is that right?
Yes, it is.
And you've otherwise set out your extensive history and qualifications in your statement and curriculum vitae attached, is that right?
Yes, it is.
Thank you. I just want to start by asking you a few questions about the history of labour force participation in Australia for people with a disability. Can you tell the commissioners, based on your extensive experience, what that labour force participation has looked like for the last 30 years or so?
We've been employed at a rate approximately 30% less than the general population during the last 30 years, Ms. Bennett, and I've described the performance of employers in terms of employing people with disabilities as abysmal, and I don't resile from that. And it has stayed at that rate, where we sit as the lowest of the OECD countries for about 30 years, as the chair indicated this morning.
So has there been meaningful change over that period in terms of the amount of workforce participation?
There's been a lot of talk. I don't think there has been significant change. There have been patches where employers at different periods of time have ramped up their efforts to employ people with disabilities, and some have been successful. Some continue to be successful, but overall, as a general comment, no, there has not been meaningful change.
What would a healthy workforce participation figure look like? What should we be aiming for?
We should be aiming to employ people with a disability at the rate that the general population are employed, around 83%, I think, Ms. Eastman said this morning, and that should be our target. People with disabilities make up 15% of the workforce, and we should be representing 15% of employment in public and private sector organisations through Australia. And it can be achieved. There is no doubt in my mind that it can be achieved, but there has to be a whole lot of change actually occur rather than be discussed in order for it to be achieved.
Now, in your history working in this sector, you've seen, I imagine, a lot of policies that have attempted to address that question. Have you ever seen an effective policy address that question of disability?
Well, I've seen some very effective policies, Ms. Bennett, but they haven't been implemented effectively. So there's little point in having a policy. And I mean, I think Ms. Eastman or the chair commented on the Commonwealth Disability Strategy, which has been in place for 10 years now, just about to be replaced by a new strategy. But over that 10 years, there's been little or no resources dedicated to that strategy. And of course, without dedication of resources and without significant commitment by government, these strategies are not effective, and that strategy has not been effective. There's some great things in the strategy, but they haven't been implemented.
All right. I'd like to speak to you now about some of the key barriers that you talk about in your statement. And I'd like to do that by reference to your own story, if that's convenient. You
Sure.
completed your law degree in 1979, is that right?
Completed my law degree in 1978 and College of Law in 1979.
Thank you.
No, sorry. I completed the degree in 1977 and College of Law in 1978. So my first year of seeking employment was 1979.
Thank you. Can you tell us about your experience of attitudinal barriers when you came into the workforce as a new law graduate looking for work?
Well, I started to apply for positions in 1979 and indicated in my application that I was totally blind. I thought it was the right thing to do to indicate that to employers, and I set out in my application what I would do to address the impact of that disability in terms of my work as a lawyer, and I didn't get any interviews. And so I decided to take that section out of my application. And as soon as I did, I immediately began to get interviews. And so the first time that employers would know that I couldn't see was when I walked into the interview room with my white cane. I did about 30 interviews during that year, and I probably wasn't the best qualified applicant for all of those jobs, but I'm sure I was for many of them, and I didn't get any of those jobs. And the only I realised at the end of that year, no, I'm sorry, let me go back. I didn't get any of those jobs. At every interview, employers didn't ask me about my disability and the impact of my disability. And so I took the time at the end of the interview to inform them what I had achieved through university and college of law, the impacts that my disability may have, and the strategies I'd use to address those impacts. And even though I did that, I didn't get any of those jobs.
Do you remember what the response was from those employers when you had that discussion with them? Sorry, at the end of the interview?
Most of the time they indicated interest, but clearly they didn't factor what I had said into their decision making, or if they did, they didn't believe it. And I can only draw the conclusion that that was because of the negative and limited attitudes which we as people with disabilities experienced at that time and still experience. To use a phrase that I often do, we experience the soft bigotry of low expectations. So
I wanted to ask you what you meant by that. I'm very interested in that phrase. Can you tell me a little bit about what you mean by that?
Well, what I mean is that people make assumptions about us, irrespective of whether we or others have put information before them which counteract those assumptions. And those assumptions are usually limiting and usually negative. And if you set the bar of expectations low, then most people, just like the glass ceiling for women, won't rise above that bar. So that's what I mean by the soft bigotry of low expectations. So if you challenged people about it, they would say, oh, no, I'm very supportive of people with disabilities. But at the same time, they make decisions which exclude us because their assumption, despite all the evidence to the contrary, and Ms. Eastman laid it out very clearly this morning with all the research that's been done, but despite all of that evidence, they still assume that we won't be able to carry out the job, or we won't be able to carry it out to the same extent or with the same capacity as a person without a disability.
Is it the case then that when you wrote in your covering letters that you were totally blind, no one was interested in interviewing you, and then you suddenly, when you removed that, you found 30 law firms interviewing you, and that tells you something about what the impact was of that, disclosing that at that point? Is that a fair summary?
Yes, it is. I believe that's exactly right. I think it's clear, and it's mirrored in the conversations which I've had with thousands of people with disabilities during my career. We have the same experience. And the reason that we don't disclose is because we know there will be a negative impact. And the only way to change that situation, if I can divert to some of the figures that Ms. Eastman quoted this morning, the only way for employers to get a real representation of the number of people with disabilities that they employ is to welcome people with disabilities, not discriminate negatively against us. So the responsibility for getting people to disclose and to indicate that they have a disability lies squarely with the employer. When the employer shows us that we won't be treated negatively, we will tell them about our disability and we will share any impacts that has or any adjustments that we may need.
Returning to your story in the 70s, perhaps now 80s, you ultimately obtained a legal job in consumer affairs. Was that a significant shift in your career?
Well, initially, after applying for the 30 jobs, I took a clerical assistance job, which was the lowest level of the New South Wales public servant. And one of my jobs was to answer the telephone and tell people the winning lotto numbers. And I used to joke in that job that I was the only clerical assistant in the New South Wales Public Service with a law degree. I moved from there to the Department of Consumer Affairs, and after a lot of conversations and encouragement and demonstration of my abilities at that department, I was given a chance as a clerk in legal and then as a legal officer. But what that required was for the supervisor of that section to change his attitude. And he, who was a colleague and became a friend, said to me, "Look, I'm not really convinced that you can do this job, but I'm going to give you a crack at it." So it just showed me that as other people with disabilities have learned, we have to prove ourselves at every step of the way in order to progress in promotions in the area of employment.
So it's not just when you're getting through the door the first time, it's each subsequent step after that. Is that right?
Yes, that's right. And that's mirrored again by the experience of many thousands of people with disabilities. And you know, the joke in the disability field is, you know, find them a job and then forget them. So put people with disabilities in at the lowest level in the organisation, and then you can say, oh yes, we employ X number of people with disabilities, or in some particular section of the organisation, which becomes like some form of ghetto or sheltered employment where people with disabilities are placed and the numbers are counted in the figures, but we never have the opportunity to progress.
We've been talking about your experience some time ago, and is it your evidence that that's what you hear from people is still the case today?
Yes, absolutely.
You speak in your statement a little bit about ableist language as part of these attitudinal barriers. Can you tell the commissioners what you mean by that?
Well, I mean language which, in the same way as racist or sexist language, disempowers and hurts women and people from culturally and linguistically different backgrounds. Ableist language is hurtful to us, but again, also diminishes the role that we can play. The example which I use, which is pertinent to me, but there are many examples which are pertinent to people with other disabilities. But the example that I use is the very commonly used phrase, "Oh, well, that person turned a blind eye to that situation." Now, what they mean by that phrase is that they ignored the situation, or they didn't take notice of the situation, or they pretended it didn't exist. But they equate those actions to not being able to see a situation. And what that says to me and to many other people who are blind or vision impaired is that it equates blindness to lack of care, lack of concern, or lack of paying attention. Of course, that's not the case, but that's the reaction that we have. And it also confirms the negative view of people who are blind or vision impaired in that way.
Thank you. I'd like to move to ask you a little bit about another of the barriers you identify in your statement, and that you refer to as organisational barriers. And it seems to me that one of these that you refer to are obtaining adjustments. Can you tell us about your experience in obtaining adjustments that you need to effectively work in a workplace?
Well, again, it's my experience, and I've been told by many others of the experience of obtaining adjustments, and it's usually most often the situation, the need for a person with a disability to request the adjustment, to seek the adjustment, to argue for the adjustment, whereas the law actually provides that employers should provide reasonable accommodation for people with disabilities. Now, I'm not suggesting that employers do that without consultation with the person with disability. Of course, there needs to be a consultation because every disability is different and people's needs are different, and the equipment that I might prefer to use might be different to the equipment that my colleague, Professor Ron McCallum, might prefer to use. But what I'm saying is that we shouldn't have to be the ones asking for it or lobbying for it. Employers should be saying to us, now, we've employed you in this role. How can we best facilitate the role in which we've employed you?
Now, you've been responsible in a number of senior roles for hiring and managing staff over a number of years. So can you tell the commissioners about how you approach that question in your practice and your work life?
Well, when I have assessed in my role as a manager people with disabilities, which I have, I've employed a number of people with disabilities in various roles. I look at their previous employment and work history and qualifications, and I assess by what they've achieved and what they say in their interview they can achieve, whether or not I employ them. So their disability is fairly irrelevant to that conversation. And when they are employed, I initiate a conversation with them about what might best facilitate your ability to continue to deliver, your ability to do this job. And we have a conversation about reasonable adjustments, and it might be a range of things. It might be something as small as a sign on someone's desk that says, I can't hear you, so tap me on the shoulder when you want to speak to me, or something as small as that. It might be making a building accessible with the addition of a $100 or $200 ramp at the front door. It might be thinking about the location of an office, allowing a person to work from home more, which we've all learned is just as effective in many cases during the pandemic. But people with disabilities have known that for the last 20 or 30 years. So anything like that which the person which may come up in the conversation, I may offer it, the person may raise it, or it may flow from a conversation that we have. But my aim as a manager is to make it as easy as possible for the person with disabilities to bring their best self to work.
Ms. Eastman recounted in her opening some evidence from Public Hearing 9 about a person with a disability working through pain because they were concerned about asking for adjustments. Is that a familiar story to you?
It's a very sad and very familiar story, yes. People with disabilities mask the impact of their disabilities and often don't tell employers about their disabilities. And the reason we don't do that, if we can avoid telling people about the impact of our disabilities, is that we have learned from years of experience that we are likely to be treated negatively or discriminated against. And that's why, as I say, the responsibility to garner that information sits squarely with employers, because employers need to show us that that situation is changing and that we will be welcomed in the workplace, not discriminated against.
And is one of the ways that employers can do that is by proactively initiating the conversation about adjustments?
Yes, I believe it is, in the way that I've just described. Another way is to celebrate success in terms of the employment of people with disabilities, to note achievement in terms of numbers of people with disabilities, to set up a disability network in an organisation, because the ability to share peer-to-peer information by employees with disabilities is valuable, and so employers, can resource that process and facilitate it, and to introduce things such as disability passports, which I've described in my statement, so that when an employer has agreed to a reasonable adjustment, that reasonable adjustment is effectively carried with the person with a disability if they transfer or are promoted. in their employment. And there's a number of other strategies to which I've referred and which the Australian Network on Disabilities indicates in their training materials, which will facilitate and demonstrate an employer who welcomes people with disabilities.
I'd like to understand your current views about targets and quotas from for people with a disability in the workplace and how that view might have evolved over time.
Well, Ms. Bennett, I used to be opposed to targets or quotas for all of the reasons that get rolled out in opposition to them. I used to say that they just caused people to, fill the numbers, fill the spaces, that people with lesser qualifications were appointed, and that they caused token appointments. I've now come to the view, and I've held this view probably for 10 or 15 years, that the only way to get people with disabilities into employment is to set targets. And I don't call them quotas because of the pejorative meaning that word has gained over the years. The only way to get people with disabilities into employment is to set targets and then develop strategies to achieve those targets. And so I have advocated for that for all of the time that I was Disability Discrimination Commissioner. And one of the most effective ways to deliver on targets is to include them in the KPIs of senior leaders in the organisation, the CEO and their direct reports, because we all know in business, it's a really well-known maximum, it's demonstrated again and again, that what you don't count doesn't count. And if we don't set targets and then develop strategies to deliver on those targets, the situation over the last 30 years will continue, where there'll be a lot of talk but not much real action.
On that topic of if you don't count, it doesn't count, does it follow then that keeping accurate data and information about the levels of representation of people with disability in organisations is important to all of these initiatives?
Well, it's critical. If you're going to set targets, then you've got to be able to measure your success. And so, yes, keeping accurate data is critical. And then demonstrating as an employer that you welcome the employment of people with disabilities, so that we then identify as people with disabilities, because otherwise there will be underreporting. It's amazing the number of times I've seen in organisations where once an organisation, and I say this to people that I'm encouraging to employ people with disabilities, once you start employing people with disabilities, even though your numbers are low, your figures will actually jump more than the number of people that you are recruiting or employing, because you will inevitably have employed people with disabilities in the past who have kept their disability a secret, because we know that we will be discriminated against if we make that information available. And so once it's shown by the employer that they are actually prepared to deliver on this process and to welcome people with disabilities, then people with disabilities will identify. And the figures Ms. Eastman quoted, and the disparity with the figures in government between anonymous surveys and data delivered as part of HR records reinforces that point. And Ms. Eastman, towards the end of her statement, made reference to the gender equality legislation, and one of my recommendations to the Commission in my statement is the enactment of similar legislation for people with disabilities, because until we start keeping and counting this data, we won't actually move the dial, the needle on the dial in terms of employment of people with disabilities.
It seems that there's almost a circularity to encouraging people with a disability to trust an organisation. In order for people with a disability to trust that the policies will do what they say, they need to see people in the organisation being treated with respect. Is that fair?
You can't be what you can't see. And so
Yes.
we need to see people with disabilities employed in jobs. We need to see people with disabilities on our television screens, in our advertising, and out and about in the general population. And we are starting to see that now. You know, figures such as Kurt Fernley, Dylan Olcott, Hannah Gadsby, just to name three that quickly jump into my head. I suppose myself in the last 10 or 15 years, Ron McCallum, a well-known Labor lawyer. We are seeing people in senior roles with disabilities. So it is starting to change, but we need to continue that momentum and continue that change because, yes, people will only declare that they have disabilities to employers when they see, either at the micro level within a particular employer or at the macro level in the general community, people with disabilities being included and accepted as part of the Australian community.
So people with disability need to see inclusion. Do they also need to see accountability in the senior levels of management in these employers?
Well, I think so. And they need to see people with disabilities in senior employment roles. I mean, so that it's demonstrably clear that can occur. And, you know, that example's been given numerous times in the last 12 months to 2 years in the National Disability Insurance Agency, just to name one of many organisations who aren't delivering in this regard.
I'd like to turn now to talk a little bit about some of the structural barriers. And one of the key protections for people with disability is the Disability Discrimination Act. Now, without speaking in detail about the minutiae of that act, can you talk to the commissioners about some of the issues that arise for employees or potential employees who are trying to use a legal process to protect their rights?
Well, ironically, and it is ironic because in the initial conversations back in the early 1990s, the Disability Discrimination Act was only going to be established as covering the areas of employment, and following, you know, lobbying and encouragement, it was expanded to cover a broader range of areas. But it really doesn't, it's not effective at gaining or protecting employment for people with disabilities. And I've made numerous recommendations in my statement as to how the legislation could be more effective. Because it deals with individual situations, by the time you get to the point as a person with a disability that you want to lodge a discrimination complaint about your employer, the employer-employee relationship is significantly damaged. It wouldn't be otherwise if you hadn't got to the point of thinking that you needed to lodge a complaint. So there's significant damage, often irreparable damage. And in any mechanisms between employer and employee, such as discrimination legislation or fair work legislation, we rarely see employees reappointed if they are dismissed. Normally, the norm is that damages are awarded. And whilst that's appropriate, as appropriate for a person with a disability as for any other employee, it doesn't fix the employment situation. So by the time the legislation comes into effect, it's virtually too late. Added to that, the complaint process is, the power imbalance in the complaint process is overwhelming. You sit down at a conciliation conference as a person with disability, often on your own or with a friend or colleague who doesn't have legal qualifications, and the employer regularly turns up with a team of lawyers, and the role of the conciliator is not to redress that imbalance. I'm sure many of them do their best. I certainly tried to when I worked in that role, but the power imbalance is significant. And then if conciliation is not successful in resolving the problem, the matter goes to hearing, and the same power imbalance is again reinforced. So the Disability Discrimination Act, in my view, has been pretty ineffective in addressing situations of employment of people with disabilities. It's been very effective in other ways, but not in that way.
All right. I'd like to ask you again about the impact of larger and perhaps more mechanised approaches to recruitment of employees generally, and the effect that has on, or that you perceive that it has on people with disability. Can you tell the commissioners about that?
Well, back when I was first looking for my first jobs, there was some chance, not high, but there was some chance as a person with a disability that you could get through the recruitment process. Recruitment these days has become very much a production line process, and has become a process which many employers, particularly large employers, contract out. And because there's no control of recruiters and the way they operate, they systematise the recruitment process. And what that means on many, many occasions is that their systems exclude people with disabilities right from the beginning. Just to look at my own disability as an example, but there are many other examples. If you have a recruitment process which requires a person to sit at a keyboard at a computer and go through a particular testing process, these processes are often not accessible for people who use a screen reader, such as myself. So immediately you're blocked from the process. And there are many other examples of recruitment where there's indirect discrimination, if you like, against people with disabilities, and they're knocked out of the race before they even get started.
So is an example of that, for example, a small organisation or a personal relationship can lead to somebody saying, much like what happened to you when you received your legal job at Consumer Affairs, and the person said, I'm willing to give you a go, in effect, because I know you.
Yep.
So that personal interaction can lead perhaps to that person overcoming their unconscious bias. Is that a fair summary?
Well, it can lead to a person overcoming their unconscious bias, and it's also not impacted on by the systematised recruitment process that often mainly larger employers use. So both those things can have an effect.
Now, I'd like to just briefly now turn to the levers that are available, that you see as being available to bring about change in this space. And you speak in your statement about disability confidence, and I really want to understand what you mean by that phrase. What is disability confidence?
Most people in Australian society, and this is mirrored by most people in employers who are making recruitment decisions, continue to make negative and limiting assumptions about people with disabilities. So one of the techniques which has been championed by the Australian Network on Disabilities and many of their employee members is training around being confident working with people with disabilities, and so that training provides the opportunity to take people who are making recruitment decisions through a training process which tries to address some of the conscious and unconscious biases about people with disabilities. And the best way to conduct that training is to have it conducted by people with disabilities ourselves, because we are a very powerful demonstration of the effective way in which people with disabilities can perform in jobs, and getting us out front of people making recruitment decisions is a very effective first step. Also, things like mental health first aid, where there are courses readily available, can remove a lot of the negative and limiting assumptions which people make about people who may have a mental health issue, and assist people to know how to address that and what action to take if they run into an employee who begins to experience that, either a current employee or a new recruit.
And are there procurement or economic incentives that can be rolled out centrally via government or other agencies that might assist in that?
Absolutely. So one of the problems which many people with disabilities experience in employment is that they get into employment, and the equipment, whether it's the desk they sit at, the software that's being used, some other piece of equipment at the employer, is not accessible. And that has an impact on people's capacity to do their job. So one of the ways in which government, federal government and state governments, could drive the procurement process is to mandate, at the moment there are some standards, but they're voluntary, is to mandate the requirement that any purchase made by government must meet accessibility standards. And what that would do, because government is such a big purchaser of equipment, whether it's desks, chairs, software, whatever, that would drive the market to make their equipment accessible for people with disabilities. So it can have a real strong economic impact on making the workplace as a whole more accessible.
Thank you very much.
Sorry, Ms. Bennett, can I just make add one more comment to that? But which is, and that's been demonstrated by the access to premises standards, because since the enactment of those standards maybe 10 or 15 years ago, building stock has been changing and has become more accessible. And so it's access to buildings for people with disabilities is not so problematic, but it can't be done by voluntary schemes. There must be some mandated process.
Thank you. I want to make sure the commissioners have the opportunity to ask you any questions of their own before we conclude this morning's evidence.
Yes, thank you, Ms. Bennett. I'll ask Commissioner Galbally first. Do you have any questions of Mr. Ennis?
Yes, thanks very much, Mr. Ennis. I'd like to come back to your comments about targets and to get you to discuss a bit more fully the consequences as well as incentives, because you had some suggestions regarding private sector and government, with efficiency dividends and tax breaks. So that's my first question. Thank you.
Thanks, Commissioner Galbally. Well, some of the suggestions I made in my statement related to incentivising government to employ people with disabilities by releasing them from the efficiency dividend, which governments take routinely from government departments if they employed a particular number of people with disabilities. The efficiency dividend, and I know this from my experience working in government, is one of those things that just gradually creeps up on you because it gradually reduces the size of your budget. And it's the bane of many, many government agencies, particularly smaller government agencies. And to provide an incentive for them to not have to have their budgets reduced by employing people with disabilities seems to me a very good way to effect the employment of numbers of employment of people with disabilities. This could be applied to the private sector in the form of tax breaks, where tax breaks of one form or another were provided if they achieved a particular target. But in order to do this, we would need data to be collected effectively, and so we'd need something similar to the gender equality legislation, which I've already mentioned.
Yeah. Would you apply such a process to the outsourced recruitment industry so that they too had targets and they too had to report on those?
Well, if I were contracting with a recruiter, I would, as one of the deliverables on that contract, require them to present me with a percentage of people with disabilities as part of their candidate pool, probably 15%, because that's the number of us in the workforce, and that could drive recruiters to do that. So employers who are serious about employing people with disability, for them that would be an easy step. They just need to put it in their tender, as a KPI in their tenders. And some organisations are already doing this in terms of their procurement. I sit on the board of Life Without Barriers, and one of the things that we do in procurement is to require our suppliers to deliver accessible equipment, or to utilise suppliers who employ a certain number of people with disabilities. And if more and more organisations were doing that, it's a very effective way to drive the market.
Yes. And could you tell us about the traffic light process that the South Australian government used with Maurice Corcoran quite a long time ago, and how that might apply today?
So that was not only, that was a reporting process in South Australia where government departments, every government department, not just departments which related to people with disabilities or were delivering specific services to people with disabilities, every department had to report annually, I believe, may have been biannually, on things to do with people with disability, not just on employment, but on the delivery of services, etc. And the reporting was red light, orange light, green light type reporting. These reports went to the South Australian Parliament each year, and ministers had to defend their departments at estimates or equivalent budget hearings around these reports. And, there's nothing like getting the attention of senior bureaucrats on an issue, but to mandate them to report on it and on how they're delivering on it.
And would that complement your suggestion about this being in performance indicators for secretaries of government departments?
Yes, it could, and it could be incorporated in equivalent to gender equality legislation. But yes, I would be mandating targets to secretaries of departments and relating them to their bonus payments. It's the only way to get people to stop doing what they've done for the last 30 years and talking about this and actually taking some action on it.
Thank you.
Commissioner Ryan?
Yes. Thanks, Mr. Ennis. I was just wondering whether you might expand slightly more on the statement you made about underreporting of people with disabilities. It's usually presented to us almost as if it's the fault of the people who don't report. And I think your interesting perspective was that, in fact, that's a KPI for a business itself. They can't complain that people aren't reporting because they're not very welcoming.
Thanks, Commissioner Ryan. I might expand on that by talking about a particular example. I'm on the board of a disability employment service called Job Life, and we employ about between 70 and 80 staff. And when the organisation commenced, I convinced the board, and I think it's fair to say there was some hesitation, but I was able to be successful, that to make part of our unique selling proposition that we would employ staff with disabilities. And we did that because we wanted to be able to show employers who we were going out to and trying to, if you like, sell candidates with disabilities, that this could be done. And I couldn't see how we could do that effectively if we weren't doing it ourselves. So we did that, and we set some numbers around employment of people with disabilities and made it one of our unique selling propositions. 40% of our staff, the figure approximately, it moves up and down, of course, a little bit, are now people with disabilities. So it's completely possible to do this if you set a target and aim to deliver on it. And I'm sorry, Commissioner Ryan, I may have missed the answer to your question, but I just thought that example was one way to demonstrate it.
Can I just get you to repeat? Did you say you have a business which has 40% of its staff have people with disabilities?
Correct. It's a disability employment service.
Yep. Look, I noticed, again, speaking from your own experience, an organisation of which you're on the board, Life Without Barriers, regularly reports that it employs 14% of people with disabilities in its annual report. I'm just wondering as to whether or not that sort of behaviour shouldn't be encouraged, because many of your recommendations to the Commission are about government. How might we encourage that sort of behaviour in the private sector? And I am wondering as to whether or not an extension of your idea about procurement might be that anybody who has anything to do with government at all in terms of purchasing, or government purchases things from them, that ought to be a mandated standard for them in their annual report. They regularly do what your company does.
Yes, I see no reason why that couldn't be a mandated requirement for government procurement in terms of contracted services, because when I began as a director of Life Without Barriers about 7 or 8 years ago now, the culture didn't lean towards employment of people with disabilities. It was an organisation which provided incredible support for people with disabilities, but we weren't employing people with disabilities. And I used to joke that whenever I walked into a different Life Without Barriers office, the immediate assumption was that I was a client rather than a member of the board. But we've worked very hard since I've been on the board, and it's not just me, that I'm not just claiming the credit myself, to change that culture. And we are gradually improving the numbers of people with disabilities that we employ. And one of the things, and we've done a lot of the things that I've recommended in my statement. So we have made it part of the KPIs for senior leaders in the organisation. And we, as you say, regularly report on it.
I was also wondering as to whether, in fact, I was going to refer to your example in Life Without Barriers. You've been on the board of that organisation for some years. Does it make a difference employing people or appointing people with disabilities to senior positions? Has that made a difference? Has that made a difference to the company that you're on the board, and that there might be other senior people in Life Without Barriers who have disabilities too?
Yes, without a doubt. Particularly for a disability service provider, it's essential that you have people with lived experience as members of boards. And in fact, Life Without Barriers last week just announced the appointment of Kurt Fernley to our board. So we've added to that approach, and I've been in the media in the last 2 or 3 months advocating strongly for the appointment of people with disabilities to the boards of disability service providers. But I think it applies more broadly. I also sit on the board of the State Insurance Regulatory Authority. I'm working now as a company director, non-executive director, and I believe that we have improved our employment numbers of people with disabilities in that organisation, and that it's partly related to the fact that I'm on the board and actively encouraging that.
And finally, Mr. Innes, your submission largely follows the presentation made by Councillor Assisting at the end of our last hearing, that the barriers to employment are attitudinal, environmental, organisational and structural. I was wondering whether you'd like to comment as to whether any one of those particular area barriers are more important than the others. I am particularly, as I said, informed by your own experience that the simple change of your employment status from basically presenting yourself as a blind person in that interview changed remarkably from what occurred that you didn't get any interviews at all when you put it on your CV. Do you think maybe it's attitudes that make more difference than almost any of the others, particularly, as I said, environmental things you observed have improved significantly?
Yes, without a doubt in my mind, it's attitudes which drives this change. And if we change attitudes amongst Australian society, and we change attitudes amongst people making recruitment decisions in employers large and small, then we will actually start to deliver on some of those policies which have been much talked about over the last 20 or 30 years. And that's why I, when I left the Human Rights Commission, was involved in the founding of the Attitude Foundation, which aims to use television and social media to have people with disabilities share our stories and become involved in that attitude change. And that's why one of my recommendations is that there should be a requirement in federal and state government advertising, and employers, private sector employers could adopt this as well, that people with disabilities are included at the level of 15 or 20% of the faces we see in advertising, because Screen Australia has carried out research that the numbers of people with disabilities appearing on screen is woefully lower than the average in the population. And as I said to Ms. Bennett earlier, you can't be what you can't see.
Thank you, Mr. Innes. Thank you, Mr. Chair.
Mr. Innes, in paragraph 52 of your statement, you say that as recruitment becomes a bigger industry and more formulaic, and you repeated this in your evidence a short time ago, the initial filtering of people has become more of a production line approach, and the lack of reasonable adjustment excludes people with disability. And I think you gave in your evidence the example of a keyboard test that would in effect discriminate against somebody who used a screen in a different way. On the face of it, if that were to happen, that would be a very clear example of direct discrimination in the process leading to the offer of employment. And I'm just wondering why you say that that would have the effect of excluding someone who a blind person, for example, from the opportunity to gain employment. Are you saying that that's because employers don't understand their obligations, or have I misunderstood the Disability Discrimination Act, or is there some other reason?
No, Chair, I don't think you've misunderstood the DDA, but you will recall that in my evidence, I talked about the challenges facing people with disabilities in terms of lodging a DDA complaint. And I know of many people over the years who have been excluded by recruitment processes which weed out people on the sorts of basis that you've described. Very, very few of them have lodged DDA complaints because they're disempowered by that process. They feel that their chances of success are not high, or they're just not aware of the legislation. So whilst the legislation says the right thing, what we need in recruitment processes is tools that actually put that law into effect. You're probably, through your involvement with this hearing, Chair, aware of the well-known French jurist René Cassin, who said it's, and I'm going to misquote, but said that it's not laws that needs to change, but it's the whole fabric of society which needs to change to achieve equality and non-discrimination throughout society. And this is one of those legislations where your outlining of the law is absolutely correct, but the burden is heavily on people with disabilities to put that law into effect. What I'm trying to suggest is strategies whereby recruiters are required not to discriminate, and strategies such as procurement, as I said to Commissioner Galbally, can enforce that by getting recruiters to provide X% of candidates with disabilities as part of the pool they offer to employers.
One approach to the particular issue that you identify with your example is to make it easier for an institution such as the Human Rights Commission to bring proceedings itself if there are examples that come to its notice of that kind, if I may use the word, of blatant discrimination. That would be a case one would have thought of blatant discrimination.
Yes, and the if the commissioner, the Disability Discrimination Commissioner, had the opportunity to complain on a class of people, he could work with the recruitment industry if he found an endemic practice which was discriminatory to change that practice. And one of my other recommendations, as you would have seen, is codes of practice, which can become enforceable codes or enforceable undertakings, call them what you will, which prevent recruiters from carrying out this sort of discrimination. And they are commonly available in other laws, but not available under the Disability Discrimination Act. I'm sure my colleague and friend Ms. Banks, when she gives her evidence, will talk to you much more about this sort of change. But it would be a mistake to assume that all of the discrimination which the DDA outlaws is addressed by people with disabilities. The number of people who complain is infinitesimal in compared to the discrimination which is out there in society.
Is it not the case that the most common form of complaint that comes to the Human Rights Commission is on the grounds of disability, discrimination on the grounds of disability?
That's correct. It used to sit around, I think it still does, just under 40% of the number of complaints. But there's only something like 2,000 complaints a year. So at 40%, that's roughly 800 complaints a year, when we have 4.5 million people with disabilities in Australia. So you can see that the number of complaints is very, very small.
Yeah. All right, thank you. Now, we've got a large number of candidates who could conceivably wish to ask you questions, that is, parties represented. But I'm going to assume that nobody wants to ask you a question unless somebody leaps up and gives a particular reason for asking you a question. Otherwise, we may be here for some considerable time. So may I assume that none of the represented parties wishes to ask Mr. Innes any questions? I shall take silence as assent, and then to thank you, Mr. Innes, for coming to give your evidence. It's been a very interesting hour, and we're most grateful to you for the assistance that you have provided and the statement that you have also provided. So thank you very much.
Thank you, Chair. It's an area about which I'm very passionate, so I'm very happy to be here.
I think we gathered that impression. So that's all right. Thank you very much.
Chair, we propose to tender the statements from today at the end of the day in one lot. And so noting that, we'd ask for 2 to 3 minutes just to reorganise the room for the next witness, Ms Banks.
Yes, all right. Well, we'll adjourn just for a few minutes in order to adjust the room. Thank you.
The Royal Commission is adjourned. The Royal Commission is resumed.
Yes, Ms Eastman.
Thank you, Commissioners. Our next witness is Ms Robin Banks, and she joins us from Tasmania.
Ms Banks, thank you very much for coming to the Commission to give evidence. We appreciate your attendance and the statement you've provided us with. Just so you're aware, Commissioner Galbally is joining us from Melbourne. I'm in the Sydney hearing room with Commissioner Ryan. Ms Eastman is also in the Sydney hearing room, and I'll ask Ms Eastman now to ask you some questions. Thank you.
Thank you.
Thank you, Commissioner.
Commissioners, you have a copy of Ms Banks' statement in the tender bundle Part A behind tab 50, and a copy of Ms Banks' CV, which appears at tab 51. Now, Ms Banks, I think you've identified a few typographical errors and some amendments that you wish to make. If it's convenient with you, what we might do is reduce that all to writing, and we'll circulate a copy of the corrections and the amendments to the commissioners and also to the parties. So with the amendments that you have identified, is the statement true and correct?
Yes, it is.
All right. So now may I formally introduce you? You're currently a PhD candidate at the University of Tasmania.
That's correct.
And the topic for your PhD is an examination of whether and how discrimination law could be used by reference to a conceptual framework that incorporates learnings from other disciplines, such as those of prejudice and unconscious bias from psychology, and what effect this might have on dispute prevention and resolution. So could I put it this way, is let's step from the legal analysis and draw on other areas to perhaps look at more effective dispute resolution ways. Is that generally what your thesis is addressing?
Yes, and it's also really looking at what the law can learn by acknowledging that there's a huge body of research, particularly in the social sciences, about the causes and effects of prejudice and stigma and how they manifest for different groups.
So prior to commencing this PhD, you had opportunity to really look inside the way in which the law works on discrimination. So you were the Tasmanian Anti-Discrimination Commissioner for 7 years.
That's correct.
And before that, you were also the CEO of the Public Interest Advocacy Centre.
Yes.
You've worked for a private law firm in which you've had an opportunity, for example, to act for employers in discrimination claims.
Yes, that's correct.
And you've also worked in community legal centres and also had an opportunity to represent many people with disability in relation to employment issues.
Yes, that's correct.
So I might describe you as having the 360. in terms of all of the different perspectives that you can bring to the experience of people with disability in navigating employment, but particularly what to do and how to address experiences of discrimination. Would that be a fair summary?
I think that's a fair summary. I also had the opportunity for a year to work at the Canadian Human Rights Commission and see the way the law operates there and some of the significant differences about the Canadian approach.
I want to ask you towards the end of the time that we have this afternoon about some of the overseas models. So I might come back to ask you about the Canadian experience.
Thank you.
But thinking about your 360 approach, you've said in the statement that based on your experience there's a level of fear in the land of employers, the fear of what if I get it wrong? What if I make a mistake and what the consequences might be? This may pick up on some evidence that Mr. Innes has just provided to the Royal Commission, but standing in the shoes of employers, what is the impact of this fear that you have observed?
In my experience, the impact is that people with disability don't get the opportunity to enter employment if that's the point, that's the relationship at the time. So they are not seen as the preferred candidates. They may not even get the opportunity to perform an interview, for example. So there's an avoidance of the risk by avoiding having the person come into the workplace. And that fear is about, well, if we get it wrong, then we'll face a complaint, which is certainly an overblown fear, but it's a fear nonetheless. In terms of if a person with disability is in the employment situation and either they acquire a disability, either through a workplace injury or otherwise, or they disclose an otherwise invisible disability, the experiences that I've heard about indicate that changes the nature of the relationship they have with the employer in ways that very often lead to the ending of that employment relationship prematurely.
But looking at the work that you're currently doing in understanding the effect of conscious and unconscious bias, it sounds that there is a bias held on both sides, that the employers may have fear, and I know we're overgeneralising and I'm not suggesting this is all or every employer, but if there's a sense of fear on this side of the employer, then equally there's also a bias from a prospective employee or an employee with disability picking up on that fear as to what the consequences might be. So it's one of the issues of how do we bridge the gap and unravel the fear on both sides?
Yeah, look, I absolutely agree that the vast majority of people with disability who I know either as friends or colleagues or who I've provided legal services to are very afraid of disclosing disability. And obviously some people have no choice in the matter. But so there's an expectation that if they disclose or if their disability becomes apparent, they will experience discrimination. And that's obviously, yes, a bias because there are good employers out there and many who will do the right thing. But the culture, unless the person has really strong confidence that the culture of the organisation is one of inclusion, full inclusion of people with disability, then there'll be great hesitation on the part of the candidate or the employee to disclose the extent of their disability or to ask for the adjustments that would make them the most effective employee they could be.
All right, so I want to ask you about that. One of the issues the Royal Commission will examine this week is the approach taken by employers at, we've loosely called it recruitment, but really this is the beginning of what is an employment relationship.
Yep.
So you've addressed this in your statement, and I want to just ask you a few questions about the approach. So when we're talking about recruitment, we're talking about matters such as advertising jobs or the word of mouth in terms of how people might look for jobs. It's about the way in which applications have to be prepared, the extent to which the applications require personal information. It might be about the way in which interviews or selection processes work. And it might also cover the pre-employment checks. So when we're talking about employment, we're talking about quite a different range of activities that really sits with the employer in terms of the employer's responsibility. So the first issue I want to ask you about is even the word disclosure. So if we think about the use of that word, disclosure suggests that you've got something to hide or a secret. Is the language of disclosure the sort of language that Mr. Innes was talking about that carries an ableist overtone? Does it suggest that there's shame in having to disclose something that's otherwise hidden?
Not necessarily shame. I would certainly say fear in disclosing something that's otherwise hidden. And that fear, for some people has borne out, unfortunately, in negative consequences. So yes, there is a fear, and in some cases it may be a shame or an anxiety that in disclosing, the employer will expect that there's going to be additional costs, and that will change the way in which their application is considered.
Mm-hmm. Is there a better word than disclose? And perhaps if we shift the language to share, we're talking about an employment relationship here, aren't we?
Well, the beginning of an employment relationship, potentially, yes. Yes, and if you use the language of share, it would make it seem that it was a trust, there was a stronger trust relationship, and that would be potentially a good thing. But people have to know that trust will be reciprocated, that there will be, in fact, mutual trust, not one-way trust.
But the very essence of an employment relationship is one based on mutual trust and confidence between employer and employee. So should we start to be using language that more reflects the nature of an employment relationship based on trust and confidence?
Certainly that would be a positive development if we could do that.
Right, but there is actually no requirement to disclose to a prospective employer that you have a disability. That's not mandatory in Australia unless there's very specific types of employment that ask those questions. And you've said that your advice to people has been, if the disability is not visible and they've asked you, do I need to disclose it? You've said you don't need to tell people about your disability, and if you don't need to, then don't disclose it. Why have you given that advice? And I think, to be fair to you, you say in the statement, there's some consequences about adopting that approach. Can you tell us about the reason you've taken this approach?
Yeah, the reason I have given that advice to people when the issue has arisen and where people have a choice, because some people do have the choice, is because I have seen far too often that, and almost universally, that disclosure has led to negative consequences for the person with disability. And I think it is really important for people with disability to understand that the environment they're in is a safe environment to disclose. And to use that word safe, it sounds like I'm talking about the experience of a lesbian or gay man outing themselves and knowing that it's safe to do so. It is a very, I think, similar problem that people with disability need to feel safe, and that knowledge about them won't be misused. And there's the safety in terms of your employer, the relationship with your employer per se, but there's also safety in terms of the attitude of your co-workers. And, I have seen some fairly negative views of people with disability from co-workers, where there's a view that, well, I have a right to know if that person has a particular disability, they are in my workplace. And it's like, well, we all hold things private to ourselves. And if that person's disability doesn't affect you in the workplace, then you really don't have a right to know. It's highly personal information for some people.
That's an important qualification, isn't it? I'm wondering about the situation of someone, and I noticed your advice and I wondered about it. Someone applies for a job, they have a disability, they don't disclose it, they get the job, and then immediately announce that they require reasonable adjustments and advise the employer of the reasonable adjustments. What is the reaction in that situation, in your experience, if it happens, of the employer? Does the employer regard that as a reasonable course?
I'm not aware of a situation where that has happened, where people require adjustments. My advice would be you need to disclose it at some stage, and I guess it's a question about what the sequence is for the recruitment process. So for me, I don't think the employer should be considering the question of reasonable adjustment until the person is a preferred candidate, at which point they should be potentially asking all preferred candidates, are there adjustments you need in your work environment? Do you need flexible work hours if you're a parent? Do you need any other adjustments? And at that point, you do the work of determining what the adjustments are that are reasonable in all the circumstances and what the cost of those adjustments are to the organisation. And then you make the final decision about whether or not that adjustment is feasible and doesn't impose an unjustifiable hardship. The risk that I've seen, and as I say, I've never seen a situation where a person hasn't disclosed and then needed reasonable adjustments. And yes, my advice would be somewhat different if it was clear they needed adjustments. But the reality is, until you get into a work environment, for some people with disability, they won't know that they need an adjustment because it's the nature of how the work is done that might give rise to the adjustment, not the nature of the work itself.
Can I jump in there for two things? One is I've got a lot of questions to ask you about adjustments related to the chair's question, but I don't want to jump to that point yet. And then secondly, can I ask you to slow down a little bit?
That was not directed to you. That was directed to me. So you needn't apologise.
But that also gives me the opportunity for both of us to slow down a little, so our Auslan colleagues can follow us. All right. So I'm going to come back on this disclosure issue. Are we right in understanding that the question of to disclose or not disclose is really going to depend on the nature of the particular job? And there has to be a two-way process on this. First of all, the employer has to identify whether or not it needs to know anything about a person's disability. And so to structure the disclosure that might be consistent, for example, with its obligations under the Privacy Act, if those obligations exist, and how we look at the collection of personal information, including sensitive information, and sometimes we call it health information. So that's step one. The second is the person who might be required to disclose also needs to understand the relevance of the information and the relevance of disclosing personal information for a particular purpose. So what I'm putting to you is a framework that exists in privacy law. And if we take a privacy law approach to the disclosure, use, storage and treatment of personal information, would that be a way that we could better think about the approach to disclosure?
Yes, I think it would be. I think it would be helpful. And I'm also conscious of the provision, at least in the Federal Disability Discrimination Act, that prohibits the asking of questions about disability if the data is used for discriminatory purposes. So that there is an interaction there as well with the existing provisions in federal discrimination law. But yes, people do need to understand what protections there are around their sharing of the information about their disability and how it impacts on them in their day-to-day work activities. And I think a privacy approach is an interesting model to consider, yes.
So if you're talking about the relevance of disclosure, you're not talking about whether subjectively the employer or employee thinks it's relevant, but the relevance comes from the context of the work to be performed.
Yes.
Would that be a way of perhaps shifting the thinking around the collection of information that might give rise to a person's disability being disclosed or shared?
I think so, yes, because it's not always relevant to the circumstances of the work being done. And there are many people I know for whom disclosing disability has never been necessary.
So you've seen in your time, perhaps the old approach was that anybody applying for a job, and this used to be in some public sector employment, that you'd have to get a medical clearance. And you'd have to be cleared by usually the company doctor or relevant health service before you would get a job. That practice has changed over time. To what extent has the requirement to have a medical test or undergoing psychometric testing an issue that might give rise to some concerns about the employment of people with disability and related to this question that we're examining now on disclosure?
To my knowledge, yes, things have shifted. I haven't been in direct employment advisory capacity for some time, but certainly as Commissioner, I was made aware of continuing practices around medicals. And I'm glad you mentioned psychometric testing, because I, in fact, received several complaints about the use of psychometric tests and their impact on people who had any history of mental illness. And so I dealt with a complaint involving the use of psychometric testing, and the response from the testing agency, so it wasn't the employer that did the testing, they had brought in an external provider. And when I asked, so if somebody answered these questions in the affirmative, that they had any history of mental illness or indeed any history of making a complaint of discrimination, which was interesting, what impact would that have on your recommendation or your assessment of that person's suitability for employment? The response I got was fairly blatant, well, we would advise against employing that person. And it was sort of irrespective of the relevance of mental illness or history of mental illness or how long ago it was to the current employment situation. So I think there continues to be a problem with the use of broad-based testing regimes as a filter for employment. And I absolutely support the right of employers to use medical testing if they can identify physical requirements of the job and they need to test a person's capacity to fulfil those. I also understand that there are times when the insurance industry needs a baseline against which to measure if somebody is subsequently injured. Both of those are completely valid reasons, I think, to conduct medical examinations prior to the finalisation of an employment relationship commencing. But too often, and I hope that the experience of people having being excluded from work because they've had a medical that says, well, this person has a disability and they can't do X, which is entirely irrelevant to the job, that is a thing of the past. But I suspect we may not be there yet.
And looking at the Commonwealth Disability Discrimination Act, that picks up not just a present or existing disability, but it also covers past disability, future disability, and even imputed disability.
Yep.
I think it doesn't quite extend to a future imputed disability, but it at least covers past, present, future, and an imputed disability. So there's quite a wide range of disabilities that could be picked up in medical clearance and psychometric testing. Is that right?
That's correct. And I would say it potentially does pick up imputed future because of the genetic testing provision. If you have a genetic history, that doesn't mean you're going to end up with that condition, but you may have a higher likelihood, and therefore there is some possibility of imputation in that case.
And in terms of acknowledging that employers may need to do some testing to work out a person's capacity, does that take us into the area of what is called inherent requirements of the job?
Yes, absolutely.
So we see this language, inherent requirements of the job, inherent requirements of the position, inherent requirements of the work, and we also see language such as genuine occupational requirements. So it can be a variation of all of those expressions. But are we right in understanding that the concept of inherent requirements of a job is to look closely at the work that has to be performed, and the employer can identify what is sort of absolutely the core functions that have to be performed, and they can be inherent requirements, but also the way in which work is done. So it's an inherent requirement of jobs that you can perform that work safely for yourself and for others who might be in your workplace. Have I very broadly summarised the concept of inherent requirements? What have I missed?
You have. I would say with a little caution about the way it is done, because for somebody like Graham Innes, for example, the way he does the job of being a lawyer is different to the way I do the job of being a lawyer, because I can read text in books and I can do things because I have vision that Graham does differently. So I guess there's the way in the sense of safety and not impacting on other people's safety in the work environment, but there is also, it is not an inherent requirement to do it the way it's always been done necessarily.
And inherent requirements is not limited to workers with disability. We see it also in other areas, such as somebody's age might give rise to an inherent requirement. I think we've seen our High Court of Australia talk about the inherent requirements of the age of Qantas pilots,
Yeah.
and that international legal obligations in terms of who can fly planes to different parts of the world had an age requirement, and that can be an inherent requirement as well.
Yeah,
Right.
So externally imposed requirements, legal obligations, absolutely. Interestingly, in Australia, it's most expressed, I think, in disability law, disability discrimination law, whereas in, say, the Canadian framework, the idea of a bona fide occupational requirement applies across the board.
In your experience, how do employers fare when they're trying to work out the inherent requirements of the job? Do we have standard systems or processes that employers have to follow to identify inherent requirements of the job, or is it a employer-employer, job-by-job type approach?
It certainly seems closer to the latter than the former. I think we have signally failed to provide the kind of guidance and resourcing that employers need to do that work well. Having been an employer myself, I've looked for what's available to help guide that, and certainly haven't found much in the way of useful guidance. And I think that comes back to the level of resourcing available to things like the Australian Human Rights Commission, but also a sense that the work of the statutory authorities is really very complaint focused rather than working with industry. And when it does that work with industry, the Australian Human Rights Commission, I think, really does drive quite significant positive change. But there hasn't been a lot of that in the employment space, as Graham identified, and I also would identify. We don't have a standard that guides employers on how to comply with their obligations under the Disability Discrimination Act.
Right. So we might ask some of the employers this week about whether they use inherent requirements as part of their recruitment processes or in the adjustments area. One of the other areas that you identified is whether employers have a good understanding of the legal obligations around reasonable adjustments, but also the practical aspects of it. So I'm going to try again to summarise at a fairly high level what the concept of reasonable adjustments mean. So this is language that we see in the Commonwealth discrimination law, the Disability Discrimination Act, and we see some variations of it in some of the state and territory legislation. But essentially, at a Commonwealth level, the concept of a reasonable adjustment is anything that a person might identify as an adjustment. Secondly, it has to be an adjustment for a particular individual rather than be an adjustment to a system. And there is no requirement to offer a reasonable adjustment unless it will avoid a person with disability being discriminated against. And that discrimination might be what we call direct discrimination, so treating a person less favourably on a comparative basis to a person without a disability. And the reason for the less favourable treatment, or a reason, is the person's disability, or something we also call indirect discrimination, which is a bit tricky to navigate, but essentially you're required to do something to meet a conditional requirement. And if you can't meet that conditional requirement and the requirement is unreasonable, that's what's called indirect discrimination. So adjustments are relevant to enable the person with disability to meet the conditional requirement. So that might be using a keyboard, for example, to pick up the example the chair raised with Mr. Innes earlier. So that idea of reasonable adjustments is not sort of something that sits alone in Australian law as a positive duty. Is that right?
I think that's an accurate, largely accurate reflection. Yes, yes.
And secondly, the adjective reasonable is completely irrelevant in terms of the way in which the law is applied in Australia in the DDA. So a reasonable adjustment is any adjustment that does not impose unjustifiable hardship on the employer. It's got nothing to do with the reasonableness of the way somebody might behave, the way somebody might act, or whether an employer thinks what they've done is reasonable. It's got nothing to do with reasonableness.
I would agree with that. I do think it potentially does some work, but it hasn't done this work, and that is that the adjustment reasonably responds to the particular need of the person. It's an adjustment that is fit for purpose, but I'm not sure it adds very much in that sense. But so it wouldn't be a reasonable adjustment to do something that doesn't address the person's need, but it changes the work environment. I would also...
Sorry, Ms. Eastman, just to be clear about it, I take it that the foundation for the questions you've been asking about reasonable adjustment is the definition of reasonable adjustment in section 4 of the DDA.
That's right, yes.
So just for people who may be trying to follow this, such as Commissioner Ryan, reasonable adjustments means under the Act, an adjustment to be made by a person is a reasonable adjustment unless making the adjustment would impose an unjustifiable hardship on the person. So the proposition you're putting is that unless the adjustment imposes an unjustifiable hardship, it is by definition
an adjustment.
Yes. I just wanted to give people
this is
opportunity to follow.
One issue I wanted to raise with Ms. Banks is that for something that was really intended to be fairly straightforward, it's become very confusing.
Yes.
For everybody, for a person with disability to know what an adjustment means, but also for the context of employers to know what they have to do or not have to do. So even the language reasonable adjustment is unhelpful, isn't it?
Yes, I would absolutely agree. And it's where the absence of really well-resourced guidance systems, and I would point to something that I think Dr. Innes pointed to, which is the idea of an employment equity approach, as we see in Canada, where the Commission there actually can assist, provide guidance to employers about, well, if you're going to, what kind of processes do you need to have in place to interrogate the question of whether adjustments are needed, and if so, how do you determine what's a reasonable adjustment in all the circumstances? At the moment, yes, I'm sure that there are many of the specialist discrimination lawyers around the country in private practice who are giving that kind of advice, but it's available to those who can afford to do that. But yes, it's confusing, and there is no doubt that a much more nationally consistent approach to understanding it and implementing it across the employment sectors would be a huge benefit.
But a good starting point would be perhaps to ask the person with disability, what do you need to do your job? And we heard in Public Hearing 9 from Dr. Beth McNally that something as simple as moving the microwave from a top shelf to something that she could use would be an adjustment to enable her to do her job. So sometimes it can just be a very small or simple matter.
Yeah, absolutely.
So in terms of reasonable adjustments, in your experience, have you seen in corporate Australia a designated person in an organisation who might be called, for example, the Chief Reasonable Adjustments Officer? Is that something that you've seen corporate Australia embracing so far?
I'm not aware of that. Generally, in my experience, the question of reasonable adjustments has been left to human resources personnel and or the person who is the direct report for the candidate's position. And when I was in private practice, I was actually asked once by the employer, oh, we've got this person who's a candidate, what do we need to do to adjust the workplace for them? And my response was, you need to ask them what then, whether there are any needs arising from their disability to enable them to not just do the job, but do it as well as they can do it.
Now I'm going to bring you back to the chair's question and perhaps unravel some assumptions behind it. It doesn't necessarily follow that you have to give your full details of the disability that you have to enable the adjustment to be made. Is it not the case that if you focus on the work to be done, then the adjustment can be made without having to disclose your full medical history, all details about your disability, because the adjustment might be relevant to some aspects of your lived experience with disability, but not absolutely everything?
Yes, that's correct. And as I said, sometimes you won't know that you need an adjustment because you haven't seen the way the work is done in that workplace. Obviously, with some jobs, it may be really obvious from the outset, but sometimes, so for example, I have a colleague who has both vision and hearing impairments, and so different work environments affect that person's ability to do their job as well as possible. So they need to avoid glare, they need to avoid a lot of background noise, and it may be that it's an open plan office, in which case that's it's harder for them to do their work well. And if it's a glass box type office, that would make it harder for them. Whereas, if it's a standard work environment where you have your own little office, you can set up the desk in such a way that the glare doesn't affect the screen, and you've got the sort of more the quieter environment, then there's no adjustment at all really needed. So it's very context specific and very job specific, it seems to me.
It's a case, isn't it, that there may be some situations where it's not possible to make a reasonable adjustment. So there may be circumstances where there's not going to be something that can be done to enable a person to perform the jobs or meet inherent requirements. So do you agree that any obligation to make a reasonable obligation has to be based on the fact that the adjustment is capable of being made?
Yes. Yes.
Okay, so in the time I've got, I want to move to the area that you've really looked at in the last few years in some detail, and also as the Commissioner, which is complaints about discrimination. So if we put it in an employment context, the possible points where complaints might arise might be at the recruitment phase, or if a person has been employed in relation to the terms and conditions of their employment, issues around promotion within employment, and the opportunity to be included in the activities of a workplace. And then the third area might be at the end of an employment relationship. So the way in which employment may come to an end. It might be forced termination, or it might be a decision to resign. So issues of discrimination can arise at each of those touch points. Is that right?
Yes, that's correct.
And when we talk about complaints of discrimination, and you've addressed this in your statement, essentially you're focusing on complaints that are available under the various statutory regimes at a federal or a state level. Is that right?
Yeah, federal, state and territory laws that prohibit forms of discrimination on the basis of disability, yes.
From what you saw in your work as the Tasmanian Commissioner and generally, how frequent did you see employers looking to offer some sort of complaint resolution dispute mechanism before you go to these bodies with the statutory functions? That was, and I'm interested in what was disability specific. So employers have got lots of grievance policies and you can make complaints and do things. Have you seen any example of effective on the ground in workplace dispute resolution models for people with disability?
I'm struggling to identify a systemic approach that would respond positively to your question, but I am I certainly have seen situations where employers have had an issue raised with them in relation to disability. They have gone to their legal advisors, usually, and in this case, I'm thinking about external legal advisors, so corporate law firms, where the law firm has sufficient expertise and understands that preventing the dispute is better than getting into an adversarial fight about, whether or not it's unlawful discrimination. So I have seen some very good work by legal advisors assisting their clients to resolve disputes before a complaint is made.
Would it be best practice that accessing the statutory schemes might be towards the last resort end rather than the first resort end in terms of dispute resolution?
I certainly think that would be the ideal. And look, I think the reality is, as your previous witness indicated, a very small percentage of incidents of disability discrimination end up as formal complaints made under discrimination law, and not necessarily because they've been resolved, but often because the person faces so much discrimination that it's about which one do you choose to pursue. And the other, I guess, one of the things that participants in my interviews have said, so I've interviewed people as part of my PhD, and I've interviewed a number of people with disability, and the very strong theme that has come out of those interviews is a view that many, many, many organisations treat disability discrimination as voluntary, the law as voluntary, compliance with the law. And so really, if we could systematise a compulsory compliance with the law and proactive mechanisms, we would be light years ahead of where we are at the moment, and it would prevent complaints.
I'm going to hear after lunch from some witnesses who are on the front line of advising clients about which statutory scheme to follow and what to do if an issue arises. And I think I'm interested in whether you've seen this experience. Some of the issues that arise are, where do I go? Do I go federal or state or territory? Things around time limits for making complaints, things around who bears the onus of proof if a complaint's made, how long the complaint process might take, the cost of making complaints, whether you need a lawyer or not. And then if you work your way through all of this, what are the outcomes that are available? Are these issues coming up in your research in terms of any one or more of those issues really being key matters that we need to look at for improving the systems of dealing with complaints under the statutory schemes?
I would say all of them have come up. The one that has come up probably loudest and clearest in terms of the federal schema is the risk of a costs order if it doesn't resolve at the Human Rights Commission level. People, quite understandably, people with disability are fearful that if they lose, and it's not even with a good complaint, it's not guaranteed you'll win, that they face the loss of home and a whole lot of other things because of an adverse costs order. So cost impact, definitely. Access to legal representation is a significant problem that many people have raised, and expert legal advisors. It's a complex area of law, as I'm sure the commissioners have become aware, and it is not an area of law that somebody could effectively dip into and say, I'm across this, I can give you advice on it. And not all advisors, including not all advocacy organisations, understand the difference between the federal and state schemes. So if they're aware of the federal scheme, which is probably the scheme that's better understood by many people, they don't necessarily even look to what the alternative is at the state or territory level. And certainly there are less risks going through state regimes because there's no cost risks, and it's happening much more locally to you. And certainly for people in Tasmania and the smaller jurisdictions, that seems to matter a little bit. The remedies are certainly important. I guess the overarching question, though, is one of a legislative scheme that relies on the most disadvantaged people in society pursuing the public good of equality. And, you know, the continuing reliance on individuals who are affected and not having any systemic mechanism or prosecutorial mechanism available in the vast majority of the jurisdictions in Australia. And even where...
Can I jump in there? Because we're going to hear from the Fair Work Ombudsman later this week. And under the Fair Work Act, she has got functions that enable her to prosecute employers for breaches of the Fair Work Act. They might be things like not providing employees pay slips or underpayments and the like. Have you looked at the Fair Work Act as a way of better protecting the rights of workers with disability in terms of it being a no-cost jurisdiction, but also the capacity of the Commissioner to commence prosecutions? And I'll ask her later in the week what sorts of things she can actually take up by way of prosecution. But is that something that you feel has sort of made its way into the options that are offered to people with disability who have employment issues?
Certainly, if the Fair Work Ombudsman has the authority to pursue discriminatory conduct through a prosecutorial model, that would be a fantastic development. I'm not aware that it's as clear as that, so I think it's an important question. I think there's also, and this is where one of the things that a number of people have said to me, including particularly lawyers and legal academics and people who've complained, is the complexity of the law and the fact that you have fair work with some discrimination provisions effectively, and then you've got the discrimination regimes under the Australian Human Rights Commission and the state and territory authorities. It's complex, you know, there's a lot of choice and it's not always clear which choice should be made. Certainly, I think a prosecutorial model, at least for systemic practices, but even then I think about, you know, for a person with an intellectual disability who experiences workplace discrimination, is it reasonable to expect them to have the wherewithal to pursue it? Some people will, there's no doubt that, and I've certainly received complaints from people with intellectual disability, but the pressure on them and the risks that they bear are so enormous that it seems that it's a hindrance to the law being effective. And I think that's what all of those factors that you identified, they hinder the law being effective, and they lead to that view that I have already alluded to, that people see the respondent or the obligation bearers seeing it as voluntary.
You've set out in a lot of detail some suggestions about addressing some of the statutory schemes that might level the playing field, if I can use that metaphor. But you've also been very influenced by some models overseas, and particularly the Canadian experience. So in the time that I have, and I know the commissioners might have some questions of you, can I ask you to tell us what is it about the Canadian scheme that you think has made a difference in the labour force participation for people with disability, but also the protection of rights while in employment? Okay, so
there are three aspects of Canadian discrimination law that I think are particularly interesting and have seen a different way to Australia. One is that their Employment Equity Act, which came into force in 1995, is the equivalent of our Workplace Gender Equality Act. And rather than just focusing on equity or employment opportunities for women, it focuses on employment opportunities for women, for First Nations people, for people with disability, and people from visible minorities. So people who experience systemic barriers to employment. And so the work that is done in that commission is really about working with employers to promote awareness of how they can audit their practices and change their practices to make them disability inclusive and inclusive of those other marginalised groups. So that it has always been a great disappointment to me that in Australia we are still in the situation where what we have is a gender equality agency effectively, but nothing beyond that, given the outcomes for those other groups. The second is that the approach to the defence of bona fide occupational requirements in Canada went through something of, revolution is probably not the right word, but there was a great, two very significant decisions in 1999 and 2000, which just coincidentally happened to be when I was there, that really clarified that the defence of bona fide occupational requirements.
Is that inherent? Is that our equivalent to our inherent requirements?
Yeah, yes, it's the equivalent, but it applies to all areas of protection. And the case in Canada was a gender case, not a disability case, where the Supreme Court said, you know, if you're going to try and rely on this defence, here are some steps you have to have gone through to show that defence is available. You can't just make it up as you go along and then come and ask for it. And, you know, the sort of messaging that it felt like was coming from the Supreme Court, if I can get away with this, is to say, look, we've had, at that stage in Canada, we'd had discrimination law for 30 years, and too often that defence was used after the fact to avoid liability. And really what they were saying is it is time to do the work of looking at the inherent requirements, the bona fide, before you make the decision, identifying how those inherent requirements are core to the purpose of, you know, the role, and that you've tailored them to be minimally discriminatory, and you've considered whether or not there are adjustments that can be made to accommodate a person with disability in any event. So a much more rigorous approach, I think, to that defence than we see here in Australia. So that's the second thing. And the third thing is that in Canada, as was the case in Australia when the Human Rights Commission had the jurisdiction to hear cases, the Canadian Commission appears as a friend of the court or a counsel assisting in, for a long time, all cases that went to the tribunal there in Canada, but now in about 80% of cases. So the decision makers are always given access to very high level legal interpretation guidance, assistance with applying the law to the facts, which means that individuals on both sides, complainants and respondents, are less reliant on having highly expert legal representation themselves, because the law is made clear by the counsel assisting. So those are three elements of the Canadian system that I think are really beneficial. The other model that I refer to from overseas is the model that exists in the US, where the Department of Justice has a particular role in investigating and prosecuting breaches of various of the US civil rights legislation, including the Americans with Disabilities Act.
Right, thank you. Now, I've probably encroached on the time that the commissioners might wish to ask you questions, but commissioners, I think we've got 3 or 5 minutes left.
We would never regard it as an encroachment. Yes, Commissioner Bell.
I don't have any
No questions. Commissioner Gelb.
Yes, look, I'd like to ask you, Ms. Banks, about your PhD and your exploration of prejudice and unconscious bias for dispute resolution, and, you know, a very serious matter for gender. And I'd just like you to discuss it with regard to disability and what you're exploring.
In 5 minutes or less.
Probably,
thank you,
probably
Galvin.
quite briefly, I think, Ms.
Yes,
Banks.
yes. Thank you. It's an extraordinarily good question, Commissioner Galbelli. So there are aspects of the way in which we as human beings make decisions that are affected by things that are other than evidence, hard and fast evidence. And there's a lot of research, particularly in social psychology, that helps us to understand the nature of those unconscious biases or heuristics which we use to shortcut decision making. And they influence all of us but if we deny that we're affected by them, then we're much more likely, I guess, to allow them to continue to impact. I note that the Law Reform Commission, I think Australian Law Reform Commission, is currently doing a reference on judicial impartiality, and they have done a very, very good background paper on unconscious bias or biases and prejudices in decision making as they affect potentially the work of judicial and quasi-judicial decision makers, and there's a lot in that background paper that reflects some of the work that I'm looking at applying. So there's changes, I think, that come out of that work to the way in which we undertake the decision making and who does it, because the vast majority of decision makers in Australian discrimination law are not people who will have experienced the kind of discrimination that people complain of. And that makes it harder for those decision makers to necessarily understand the nuances and complexities of discrimination, particularly as it's experienced by people with disability. There's one aspect of the research that I'm looking at, which is a model to understand prejudice that means that the way that what people with disability experience as prejudice-based behaviour is much more likely to be paternalistic, overprotective, and avoiding putting the person in a situation where they may have to perform at a high level. So it's described as pitying, a pitying approach that is driven by a view that people with disabilities are less competent than others. Different groups, this model, which is Susan Fisk's work in the USA particularly, the model says that different characteristics drive different forms of prejudice. So some prejudice is outright hostility, some prejudice is this sort of pitying and under expectation type prejudice, and that looks very different in terms of what the discrimination is that it drives. So Graham Innes, I think, talked about the burden of under expectation, and that's certainly a particularly disability directed form of prejudice-based behaviour. Certainly Aboriginal people talk about it as well. But so it's all of that kind of work and thinking, how could this reshape the way in which we think about discrimination and regulate it in the law?
Thank you. Thank you.
Very concise description of your PhD thesis, if I may say so.
Thank you.
As far as the drafting of the legislation is concerned, one has to be very careful not to criticise too much parliamentary counsel or drafters. My own experience with drafting of legislation and people who draft legislation is that it's an astonishingly difficult thing to do and generally is done very well. But when you combine Section 5 of the DDA with a rather odd definition of reasonable adjustment, pay attention, Ms. Eastman, this is important. What you get is something like the following. An employer discriminates against an employee if the employer fails to make the adjustments the employee requires to do the job satisfactorily, unless providing the adjustments would impose unjustifiable hardship on the employer. That's effectively the combination.
Yeah.
Professor Julia Stone very famously said that the law contains categories of indeterminate reference. Reasonableness is one of them, but another one is unjustifiable. And all that has happened in these definitions is that the category of indeterminate reference has been transferred from reasonable to unjustifiable. I'm not sure it's all that difficult to understand. I think it's to do with the vagueness of the relevant criteria, which, again, I'm not sure is unique to this particular area. That's the end of the soliloquy, Ms. Eastman. Yes.
I'll probably just throw in the mix there, Chair, Section 11 of the Act as well.
Yes.
I've got no further questions for.
All right,
Ms.
well, I'll
Banks,
make
if
the same
that's-
assumption as previously, that is that there are no further questions to be asked of Ms. Banks. And I thank you for your evidence today and for the statement that you provided to the Royal Commission. They've been very helpful. Thank you very much.
Thank you for the opportunity.
Now, it's just after 1:15 Eastern Summer Time. I take it that we will resume at 2:15.
At 2.
At 2, that's not what the draft says.
Oh, is it? I think my
I'm
program has
I'm looking at the wrong draft, am I?
at 2 p.m.
2 p.m. All right, we'll resume at 2 p.m.
Thank you, Chair.
Thank you.
The Royal Commission is adjourned. The Royal Commission is resumed.
Yes, Ms. Eastman.
Commissioners, we now have a panel of Ms. Kirsty Wilson, Ms. Melanie Schlager and Mr. Peter Oliveri. So I think we can now see them all on the screen. Can't see.
We're short of
One person is missing. I'll just check everybody's on and the commissioners, you
Yes,
can see
now
everybody.
we have Ms. Schlager, I think. So everybody is present and correct. Thank you very much for coming to the Royal Commission to give evidence in the panel today. We're grateful for your assistance to explain where everybody is, at least everybody relevant. Commissioner Galbally is joining the hearing from Melbourne. I am in the Sydney hearing room with Commissioner Ryan on my right. Ms. Eastman, Senior Counsel Assisting, is in the same room as Commissioner Ryan and myself. I'll now ask Ms. Eastman to ask you some questions. Thank you very
So
much.
I might start just by introducing everyone. So Ms. Wilson, can I start with you? You are the Principal Legal Practitioner and CEO of the Association of Employees with a Disability. The shorthand is AED, and that's a Community Legal Centre, is that right?
That's correct.
And you prepared a statement for the Royal Commission on the 12th of July this year. Have you got a copy of it?
Yes, I have.
And are there any changes that you wish to make to the statement at all?
No, there's not.
And can we take it that the contents of the statement are true and correct?
Yes, that's correct.
Thank you. Ms. Schlager, can I turn to you? You are the manager of the Equality Law Program at Victorian Legal Aid.
Yes, that's correct.
And you've made a statement for the Royal Commission on the 5th of November this year.
Yes.
Are there any changes to your statement?
No, there aren't.
And are its contents true and correct?
Yes, they are.
Right. Now, Mr. Oliveri, I'm going to ask you a few questions before I come back to the two lawyers and ask them. So you are a person with disability, and do you mind me saying that you have a heart condition? And I think we need to get you off the mute so we can hear you. I'll just ask my colleagues here whether they can assist.
You got me now?
Yes, I've got you now. So, Mr. Oliveri, welcome.
Thank you.
So you are a person who identifies as a person with disability.
Yep.
And you had a dizzy spell when you were on a night shift back in July 2017. Is that right?
That's correct, yes.
And that dizzy spell meant that you had to get some medical advice and medical treatment from your doctor.
Yes.
And after you experienced the dizzy spell, you needed to take some time off work.
Yes.
But you still felt a little bit dizzy and unwell when you went back to try to resume your normal working duties. Is that right?
That's right, yes.
And then after a period of time, you got a call from your employer, and I'm not going to identify your employer, and you were ready to go back to work, but your employer said that he didn't have any more hours for you.
That is correct, yes.
And your memory is that your employer never asked you how you were or how your medical condition might affect your ability to do your work. Is that right?
That is correct. Yeah, no contact whatsoever.
And you'd had some surgery to have a pacemaker inserted.
Yes,
And after that, you felt that you should be able to get back to work to do the job that you'd been doing for a long time. Is that right?
that is correct. The cardiologist that put the pacemaker in said you'll probably miss a couple of days. You'll be a little bit sore, but he said if you feel up to it, you can go straight back to work.
Right. Now, you were gutted, weren't you, when your employer said that you'd no longer have your regular hours?
Oh, totally, yes.
And you were very concerned about losing your income.
Yes,
And you sort of thought, well, what am I going to do about this? What are my rights in this situation?
yes, that's correct.
And so in terms of working out your legal rights, the first step is that you spoke to some friends and colleagues. Is that right?
That is right, yes.
And then can you tell me how did you work your way through to end up with Victorian legal aid? Because it took a little bit of time, didn't it? And going through a number of different people before you got to the Victorian legal aid.
Yes, that is correct. I went originally to an advocacy where we had a phone hookup with Fair Work, I think it was. That wasn't resolved at that. It was then moved on to a VCAT hearing, and nothing was resolved at that mediation. They then said that they couldn't take me any further because solicitors, barristers, everything had to be involved. So I then went to a law firm that I'd had some dealings with and got all my paperwork, went there. After a couple of weeks, I got a phone call to say, look, we really will be the only ones that will make any money out of this. It's really not to our, your benefit to have us represent you. Why don't you call legal aid? And that's what I did.
So when you contacted legal aid, I think you were actually surprised that anybody would call you back from legal aid. Is that right?
Well, the first phone call I got on to somebody that I really don't think knew what he was doing. I think he might have been just the work experience guy on the day, and he couldn't help me whatsoever. And through a friend or a lady that I was going out with at the time, she said, nah, ring them back. And then after the second phone call, I got onto a guy as well, explained my situation, and he said, look, I will take your number and somebody will ring you back. And I sort of hung up from that phone call and said, yeah, it won't happen. And then that afternoon, I got a phone call.
And so you then met up with the lawyers from legal aid, and the legal aid lawyers engaged a barrister as well to assist you with the hearing in the VCAT, the Victorian Civil and Administrative Tribunal. Is that right?
That is correct, yes.
And I think you formed a view that, and I'm just going to put this in, Commissioners, as a plug for barristers, but that you had a barrister and you described her as like a dog with a bone. She was a real go-getter and you were completely confident and very happy with the way you were represented.
Oh, extremely, yes.
It's very unusual perception.
Well, I haven't had a lot to do with the legal team.
Right.
And the experience of being represented sort of gave you confidence, didn't it, that you were going to get a fair outcome for the issues that you wanted to raise. Is that right?
That's right. And look, until I got to legal aid, I still thought that I was having an unfair dismissal case until they said, no, it's a disability discrimination case.
Yeah.
Um,
So I think during the process, you were a bit unclear about like what law is applying to me and which court or tribunal did I have to go to, and it was all a bit confusing, wasn't it?
oh, totally. Yes.
But at the heart of it, you felt that you really had been given a raw deal by your employer and you really wanted to take some action because you felt it was unfair.
100%, yes.
And by losing your job, that has had an impact on you financially.
Yes, it did, yes.
And notwithstanding that you lost your job, you weren't able to get your job back through this process, were you?
No.
And so the outcome was something other than to get your job back, and you've had to move on and look at different options for your life in terms of employment. Is that right?
That is correct, yes.
Now, thank you very much for sharing that experience. And I want to turn to our two legal practitioners on the panel. Is Mr. Oliveri's situation something that is unique, or is this a situation that comes across your desks on a frequent basis? Ms. Wilson, can I start with you?
Yes, we have, over the 20 years I've worked in this space, basically I have represented thousands of people in similar situations, obviously, you know, different circumstances, but yes, it is very common that, well, a couple of things, that they don't have the access to justice. They find it very difficult to find representation. We are around Australia, we're the only specialist legal centre, community legal centre that only specialises in this particular area. There are some in other states where there's just a couple of lawyers who do it sort of part-time. It's a shame because there is such a need for that representation and the knowledge dealing, you know, of the situation that Peter has described is, yes, it is common, unfortunately, but it's something that, you know, really needs to be addressed.
Can I ask you a little bit about the legal centre that you operate? So I think you've said you're the only specialist legal centre with respect to these issues. So can I just narrow down on issues? Are you a legal centre that really focuses on the rights of people with disability in the context of employment, and that's the primary focus of the legal centre?
Yes, we're actually funded by the Department of Social Services under the National Disability Advocacy Program. So we're not funded the same way that the other community legal centres are funded. We are funded specifically to represent people with disabilities in the area of employment and education. But around 70 to 75% of our clients have employment issues. The other 25 have educational issues. And obviously there has to be a link between the disability and the issue, the employment issue.
And we might talk in a moment about some of the cases that you've been involved in and the systemic issues that arise. But in terms of getting a sense of your caseload on an annual basis, you've told the Royal Commission of the information that you have been able to provide to us. Looking back at the financial year of 2018 to 2019, you had a caseload of about 300 clients. Would that be sort of indicative of what the caseload would be?
It has been in the past. This last 12 months, it has been less. It's approximately 150, and a lot of that is to do with COVID and a lot of the clients who haven't been working. And, you know, obviously in Victoria, people haven't been going anywhere. So our caseload has dropped off. We are getting, you know, 2, 3, 4, you know, up to 6 calls a day now for assistance. I mean, obviously, if they don't fit the criteria, we can't do anything about it. But our caseload has increased a great deal in the last little while.
And in terms of the legal services that you provide, do you charge your clients to represent them or to advise them?
No, there's no fees whatsoever. The only responsibility that the client has is the disbursements. But again, we try and seek ways to potentially, alleviate that sort of cost. So if the client will speak to the doctor, sometimes the doctor won't charge. Whereas if we write as a legal letter, they will turn around and charge, anything from $800 to $1,500 for a report.
Okay.
So
just to interrupt, just for people following us, disbursements is a little bit of a shorthand term that we use as lawyers, and that might be the cost of photocopying, the cost it could be the cost of getting a report from a medical practitioner. Sometimes disbursements can be additional costs like hiring a barrister. Is that what you mean by disbursements?
All right. No, what I meant by disbursements is filing fees and doctor's reports. So the client doesn't pay anything for photocopying. That's all included. They don't pay. We would go through Justice Connect to find a barrister pro bono, or we had a hearing last week and one of the staff did it himself. So we will do everything we can to ensure that the clients don't have the cost of the actual hearing. And we do obviously talk to them about, depending on the jurisdiction as to whether there is a cost risk. But we do a lot at VCAT and also Fair Work, obviously, where there is that.
And I want to ask you about some of the different places that you can go. Can I finally just ask you, how many lawyers are part of the team at AED Legal?
There's 2 others at this stage.
Okay. Can I turn now to Victoria Legal Aid? So, Ms. Schlager, can I ask you, you're the manager of the Equality Law Program. Can you tell the Commissioners what is the Equality Law Program and what legal services do you provide to people with disability in the context of employment matters?
Yes, the Equality Law Program at Victoria Legal Aid is a small team of lawyers who specialise in the area of discrimination law. We provide advice and assistance, including representation to people with complaints of discrimination in a range of areas, including disability. We also provide assistance in other areas of discrimination, such as sexual harassment, race discrimination, and so on. The majority of our work is in the area of employment. We also provide assistance in relation to discrimination on the grounds, in the area of education and other areas that are covered by discrimination laws. We provide assistance in a range of jurisdictions, including under the Fair Work Act, federal anti-discrimination laws, and the Victorian Equal Opportunity Act.
And how many lawyers are in your team?
So there are 5.6 FTE of lawyers, including myself, which means really 5 lawyers working primarily, on discrimination matters, as well as undertaking strategic advocacy in various focus areas.
In terms of the cost of the services provided by Victoria Legal Aid, it's a process, is it not? And I think you described this in the statement, and Mr. Oliveri has described it, is that you have to make an application for legal aid and that there's some criteria that has to be satisfied before a person will be represented by legal aid. Is that right?
It depends on the stage of the matter and the intensity of assistance that's provided. So we provide telephone advice. Well, now it's previously it was also in-person advice to people, and there's no financial eligibility criteria at that stage. However, the matter does need to relate to a discrimination inquiry. And beyond that, we can provide assistance under what's called a minor work file, and that's some limited legal assistance. And there is slightly more rigorous eligibility criteria at that stage. But in order to receive a formal grant of legal aid, which is required for us to provide representation in litigation, there is eligibility criteria under our funding guidelines.
Right. So I want to ask both of you, and Mr. Oliveri, jump in if you've got some observations that you want to make from your experience about some of the issues that arise for people with disability who look to the law and to statutes or laws like the Disability Discrimination Act or the Equal Opportunity Act in Victoria or the Fair Work Act to stand up for their rights. So in an employment setting, the issues might arise at the time that they're seeking a job at the recruitment stage. It might occur when they're in employment in relation to the terms and conditions of their employment, how much they're being paid. It might apply to whether they are promoted into jobs, but it also arises at the point of termination, which was Mr. Oliveri's case. So I wanted to ask you, with respect to each of those stages, in your experience, are people with disability aware of their rights at these different parts of the employment experience? Ms. Wilson.
I would say on a whole, no. I think particularly during the period of employment, the majority of people with disabilities wouldn't know of their rights. There is obviously concern, for example, disclosing what their disability is. How will they be treated? Will they be treated differently if they disclose, like obviously Peter was in his case? So when they at termination, though, I think that there is perhaps a little bit more awareness, because it does, it is occasionally in the on the news and that sort of thing about people being terminated from employment and that. So yes, I think at that time they might be aware that they do have rights. They often don't know about the time restraints, though, that you've got 21 days to put in your application. And we often, not so much often, but we do get cases where they are out of time, and then we have to decide, is it worth the fight to try and because you've got to have a hearing as to see, for jurisdictional arguments. So basically to see whether we can get it past the line of it being over, or out of time, or we then have to, should we go to, depending on the employer and themselves, do we go to VCAT or do we go to the Australian Human Rights Commission to try and, perhaps put in a complaint? And we also weigh up what the position is. Have they had, years of being discriminated against while they're in the workplace? And therefore, if we go to VCAT, for example, or Australian Human Rights, we can bring in that information and get, and look at pain and suffering as well as compensation.
Can I jump in there? Because that sounds like a lot of things to know about if you're knowing about your rights. So I'll come back to some of the detail of that, but the sort of question is really about awareness of rights. And so that, am I right in understanding that people might have greater awareness of their rights if they're terminated from their employment, but less so in relation to what happens while they're in employment or the steps around getting a job? Am I understanding?
Yes, I would say that's the case. I think it's very much, while it's particularly also while they are employed, they don't want to do anything that might jeopardise their employment too. That is always we do get a number of cases where their employment is at risk because of their disability and the situation. So yeah, there's a lot of fears and of knowing what rights do they have and how can they get those rights. Look, who's going to support them in having their rights addressed.
So can I ask, is it a similar experience for Victoria Legal Aid in terms of awareness of rights?
Yes, it is. And I think it goes to your earlier question, Ms. Eastman, about whether Mr. Olivieri's experience in knowing where to turn to for help is unique. And I don't think it is unique at all. I don't think many people would be aware that Victoria Legal Aid can provide assistance with discrimination law matters. Unfortunately, much of our work is invisible. Matters very rarely go to hearing. Most of them settle and most of them settle on confidential terms. So it is difficult for people to know where to go, and it's difficult for people to know where to get quality legal assistance because it is a complex area of law, discrimination law and employment law, and you need to have expertise in both areas to provide really meaningful assistance to people. So I think that is the initial major hurdle that people, well, perhaps the second hurdle that people face, and the first is knowing that there's a legal option available or options available to them. And I think, as Kirsty mentioned, there are the two issues, people just having an awareness of their rights, that perhaps there's something they could do if they face disability discrimination in recruitment or during employment. And then also wanting to take that action given the potential adverse consequences that can flow from exercising one's rights or making a complaint. And in terms of termination, at that stage, one of the reasons I think that people might come to us more regularly at that stage is both because, as Kirsty said, perhaps there's greater awareness that there are legal rights and options if you're unfairly dismissed or unlawfully dismissed for a discriminatory reason. And also we receive referrals from other organisations that people might contact, such as the Fair Work Ombudsman or Human Rights Commissions. So they might not come initially to Victoria Legal Aid, but they might come to us once they've contacted another agency and been referred to us for assistance.
Can I ask you both this? Is sometimes when we think about worker and worker rights, we might ask whether or not there's unions who represent workers at the workplace. In your both your experiences, have you seen that there are union representatives who can provide advice and assistance to workers with disability in the workplaces that you've come across? Perhaps if I start with you, Ms. Schläger.
Sometimes there are, and sometimes there aren't. But I should qualify that by saying I wouldn't see the vast bulk of that work that unions would be conducting. So I'm probably not best placed to say.
Ms. Wilson, have you seen union delegates or union officers involved in assisting workers with disability know what their rights are?
I have over the years. We have worked with a number of union delegates so they often bring clients to us and we will work together in representing them. I think that the difficulty is that they don't know, that whilst they know the industrial law, they don't, working with people with disabilities, sometimes it's they're not quite sure of what actions that they can take. So yes, I have, but not in a great deal of not often. It's it's not all unions that I have seen it in. There's just a few.
So I want to ask you about if someone comes and seeks your services. The description that you've both given sounds to me like a very complex situation, that there might be different laws and different processes to follow. Is the starting point to be really clear about what outcome or what remedy the person is seeking, and that determines what options might be available? How do you perhaps start with Victorian Legal Aid? Do you start with what does the person want to achieve out of a legal action, and would that determine what steps you take?
Absolutely. That's our starting point, is to identify the person's interests. And it may be that discrimination law isn't the solution and isn't the best way to address that person's interests. But that is always an excellent starting point, because it can help us to really target the best possible avenue to help that person achieve their goals.
Ms. Wilson, what, in your experience, do you look at what the outcome is that the person's seeking?
We do. However, we also have to look at, do they meet our criteria, which sounds awful, but we are funded and to represent people, in those particular areas, and it has to relate. So if the issue doesn't relate to the disability, so they might be employed and something else has happened, and it doesn't relate to the disability, then they don't fit our criteria. So we would have to refer them to somewhere else. So just because a person has a disability and they're employed, it doesn't mean that we can do it. So that sounds awful, I know, in some ways, but because our funding is limited, we do have to abide by those guidelines. But in saying that, when we talk to, obviously we talk to each client beforehand and we work out, and if there's any way in the slightest that we can fit them into the criteria, we will. And then we will look at, a number of things to see, basically to work out where we're going and what remedies. So we talk to the client, obviously, about what they're looking for, and that often dictates to us which way where we're going to go with the case.
Okay.
I don't want to intrude on Mr. Oliveri's privacy, but if possible, I would like to understand what the basis of Mr. Oliveri's claim was. I take it that the claim was that he was dismissed by reason of disability. Is that the basis of it at VCAT? Does anybody know?
Yes.
I'm sorry, I may be under misapprehension. I thought that either that Ms. Wilson may have been.
No, so
we don't know. All right. Okay.
It was about, sorry, Ms. Schlager, do you want to answer this before I jump in? So probably best.
Victoria Legal Aid represented Mr. Olivieri at VCAT after the mediation at the hearing, and it was a claim of discrimination on the grounds of disability. He had a number of claims, but yes, it was basically discrimination on the basis of his disability.
Was there also a workers' compensation claim?
No.
No?
And it was brought under the Victorian Equal Opportunity Act.
I understand that, but I'm a little puzzled as to why there wasn't also a workers' compensation claim.
Well, this is, if I can perhaps use that chair to come back to this question about working out which pathway you follow might depend on the outcomes that people are seeking. So if you start by saying, what does the person want to achieve? There's a couple of factors then that follow. One might be, how long will it take to possibly achieve that remedy? How much will it cost to achieve that remedy? And what are the processes available to a person in achieving that remedy? Do they have to go straight into a court hearing, or is there other options of private resolution through a mediation or conciliation? So can I just ask, again, the legal practitioners, are they factors that you take into account?
I'll jump in there. Yes, they are. What we would do is, depending on the matter, it might be that we would start off with actually trying to organise a meeting with the employer so that we can assist them in trying to resolve the, do they need some workplace modifications? There are obviously different areas, that you can go to get some of these modifications. It might be that the employer doesn't recognise the disability. They might, there's a range of things. So we will try to start from the ground and then work our way up. Obviously, it's not in anybody's best interest to go straight on to hearing. So as I said, we will try and start at the beginning. And then we, depending on the situation, if it's termination, we will look at whether we go through Fair Work or whether we put in a complaint, or if it's too late. It just depends on the stage. But it's basically we try and have a meeting first with the employer, then we put in a complaint and always ask for a mediation, because a mediation allows the parties an opportunity to meet with an independent person, independent umpire, and they have an opportunity to say before it goes to hearing. And, probably 95% settle at mediation or conciliation, because, it gives our client the opportunity to have a say, to have some control in the outcome. Whereas if it goes to hearing, it's out of their control completely. It's whatever is the decision at the end of the day. So that's what we look at.
And from Victoria Legal Aid, if, for example, let me just use a hypothetical, somebody has lost their job and the outcome that they're seeking is they'd like to get their job back, so they'd like to be reinstated. There's some pretty tight time limits, aren't there, to bringing a claim of concerning unfair dismissal to the Fair Work Commission, and different timeframes for the Disability Discrimination Act, and then another different timeframe under the Victorian Equal Opportunity Act. So if someone needs a quick remedy and they want to get their job back, how do you sort of work through what the best options might be for the client?
Yeah, as you mentioned, there are a whole range of factors that would influence our decision about which jurisdiction we think someone should take to pursue a remedy, and whether the person wants their job back is a key factor for us to consider. And often the Fair Work Commission is a good option because you can proceed with your dispute fairly quickly and get to a conciliation fairly quickly. Having said that, you have to make a complaint within 21 days if it relates to a dismissal, whether that's unfair dismissal or a general protections application. And that is really a really quick time limit for someone with a disability who may have other factors going on in their life. They may be in a state of crisis and they may not be able to process legal information that quickly, or seek legal assistance, or be aware of their legal options. So it's really problematic. And even the longer time limit under the Disability Discrimination Act is still, we say, not long enough. There are a whole range of reasons why someone might not be able to meet the current time limits under discrimination law.
In both your experience, if somebody wants their job back, it's important, isn't it, that there be a process that can get a quick outcome, because the longer it takes to resolve the dispute, the less likely it is that someone will be able to get their job back.
Well, I think
that's been your experience.
It is my experience, but it's also fairly rare in my experience that clients come to us and have been dismissed from their job as a result of their disability and do want their job back after an initial period of negotiation with their employer. Often that process can be so off-putting that they no longer want to work for their employer, the previous employer, anymore. We do try to, we can achieve sometimes really great outcomes for clients who haven't been dismissed from their job and contact us prior to dismissal, where oftentimes we'll stay out of the picture but let the client know what their rights are and work through with them how to have a productive conversation with their employer. And sometimes that can achieve really positive outcomes. I can also answer the Chair's question about workers' compensation claims, because I think it is, it's a really pertinent question. We often do advise people to make a workers' compensation claim. We don't provide assistance in the area of workers' compensation, so we would refer clients to other law firms who specialise in that area. Sometimes we work collaboratively with workers' compensation firms on clients' matters, because it is very complex when a client has both a workers' compensation claim and a discrimination claim, and sometimes even, another a superannuation insurance claim. So disability discrimination in employment can raise a number of legal options, but like other claims, as time moves on, that workers' compensation option becomes more challenging for the individual to pursue.
Ms. Wilson, I think you mentioned earlier that sometimes you've got clients who have experienced discrimination in their workplaces over a long period of time. By that, do we understand that there might be a range of different things that have happened to them at work that could be acts of discrimination in isolation, but when you put it together, it might cover treatment over a longer period of time, and that treatment sort of adds up to a person feeling that they have experienced discrimination or harassment, for example?
Yes, that's correct. And when they come to us, and that's when we make talk to them about what their options are, because if you go through unlawful termination, we only do unlawful terminations, because obviously the termination is we're alleging that it's because of the disability. So we don't do unfair. So when we look at that, it's really only the termination that is decided upon. Whereas if we put in a complaint either at Australian Human Rights or at VCAT, we can get the whole picture. So leading up to what's happened in the last few months or the last few years, we can put all of that in there and present that as a whole. And
can I ask you on that though, is it not the case that if you're going to bring a claim like that the onus is then on the person with disability to say this is how they prove the discrimination has occurred? And how do you do that if there's been a lot of things that might have happened to somebody over a long period of time? Is that hard?
Look, it is hard at times. I guess what we do is we hear what the client says, and sometimes obviously you can't, the client doesn't remember the dates, but there's enough the information that's there that we can bring together a picture. So it's basically telling a story. This is what's happened over, and it might be that the person's been there for 10 years and the first, 7 years were great, and then there's a change of management, and then things start going wrong. And from that, and you can point out, you can pick when the things have changed, the attitude towards the client has changed. And so it is hard. However, by bringing that, and often the clients don't realise, but they do have, they can picture it to certain events that might have occurred, and then so the timing, we can work out the timing of when things occurred, or they might actually have something that a letter that we can attach to the complaint that will give some of that background as well.
And ask both of you on this question of the onus of proof. You both addressed this in your statements as being an issue the Royal Commission might want to look at. And am I right in understanding that the question about the onus of proof being on the person with disability to prove all of the elements of discrimination can be difficult, but if you've got some Fair Work Act claims, the onus of proof is on the employer to almost disprove that disability was an operative cause? How does that question of the onus of proof impact on a person with disability getting justice if they've experienced discrimination? Perhaps I'll start with Victoria Legal Aid. Has that come up on the question of proof?
Yeah, it's regularly a problem. It's very problematic for employees in particular. We often talk about employers having this monopoly on knowledge and evidence. So it's, difficult for employees to get witnesses to disability discrimination to speak up on their behalf when those witnesses are still employed by the former employer or still have a relationship with the former employer. And we think that it would be really helpful if there was a shared burden of proof at least, or one that shifts to the employer once the employee establishes a prima facie case of discrimination.
I'm just conscious of the time, and I know the commissioners may have questions for you, but if you reflect on all of these issues that we've talked about today, about the different laws, you've all said it's complex. Peter's talked about knowing about his rights. What are the reforms that you think would make a difference? So, Peter, can I start with you? Looking at what happened to you, what do you think would make a difference? What should change?
I think probably because people like myself don't have an understanding of the legal side of things. Like most people today, if you walk down the street now and say, hey, if you just got sacked, what would you do? I'll bring Fair Work. And I think, until I was in contact with that advocacy, I wasn't aware of the 21 days, and probably a lot of people would turn around and say, well, what's the 21 days? And as you said, you've got to have your application in within the 21 days. And that was one thing. My employer came back, and when they were asked, why didn't you sort of contact Peter? Because he'd already made a claim. And they sort of obviously weren't under the understanding of the 21 days either, because they said, because he made the claim so quickly. And I think, under my knowledge, that was a get out by them anyway, to use that. And I just think, for the average Joe that goes through this, that doesn't have a law degree, it's a total black hole. And where do you go other than go to a legal firm or whatever, and then be told it's going to cost you a fortune? And I really think most people, and I was inclined to do it myself, just back away and not go on with it,
Ms. Wilson, what are your suggestions for change? I know you've set them out in some detail in your statement, but what would you like to tell the commissioners?
Look, I guess I would like to see more legal centres specifically for people with disabilities. Not just obviously employment and education, but employment and education. They're huge areas, and there is such a need. If we advertised, we would just be inundated by calls. We get referrals from Fair Work. We get referrals from all over the place, law firms, unions. So it would be great if there were more throughout Australia. I mean, it's just such a need. And also education. I think education for people with disabilities, but also for employers, because I mean, I've attended meetings and I've been told that I'm not allowed to speak, and nobody tells me. I mean, that sounds awful, but I'm there. I'm representing my client, and I will represent my client. Our clients have got a right to representation, but often employers don't know that. And, it's all very well the union could go in there, but so can we. We can represent the clients in the workplace if they need to. We also, I think that employees need to understand that they can have a support person there and a witness. And a lot of, when you talked about the evidence and the burden of proof, if an employee attends a meeting and they've got a witness with them, at least that is somebody else who has, even if they don't say anything and they just take notes, it is so important. And that is something that I think is really lacking, is that it's just not known that you can have a support person. And in fact, you should be offered one.
Schlegel, what are your suggestions for change? And we haven't been able to go through all the detail that you provided in your statement about some of the features of the Victorian law, about positive obligations and the like. But from your experience, what would you like to see change, and what would you like to say to the commissioners?
So I agree with Peter and also Kirsty's points. In addition to those points, I think that currently the legal, social and financial penalties for employers who fail to comply with discrimination laws are non-existent, really, unless a victim of that discrimination chooses to complain or take legal action, as Peter did. And that's a very heavy burden for victims of disability discrimination to bear, and it doesn't promote inclusive workplaces. So my takeaway point, I guess, would be that human rights commissions should have greater powers to enforce discrimination laws, including the power to seek penalties for non-compliance. And I think that discrimination laws are much more effective if there is the threat of penalties or sanctions for non-compliance. So I think that's critical.
When you're talking about penalties, are you talking about something equivalent to the civil penalties that exist in the Fair Work Act for certain contraventions, or something different?
Yes, that's right, civil penalties.
Commissioners.
Commissioner Galbally, do you have any questions of the panel?
And I'd like to refer Ms. Schlager to your paragraph 41 about intersectional discrimination, and particularly with regard to women, as to, you know, when you look at the UN committee and the complaints about women in Australia with disabilities, what's your experience in your practice about women coming forward?
Well, I would need to take that on notice in order to provide you with a breakdown in terms of the number of clients with disability who are women, and we can do that for you. However, my observation as a practitioner is that there are a range of ways in which people with attributes that mean that they are not the kind of, I guess, white male breadwinner, full-time worker norm experience discrimination more than other people. And so women experience discrimination in a whole range of ways. And we see, for example, that women who experience sexual harassment often develop a disability as a result of that experience. So the experience of disability can result in discrimination that can be unique because that person is a woman, and the discrimination might involve an element of, say, gender harassment as well. But conversely, people with particular attributes can develop a disability as a result of the discrimination that they experience.
Thank you. I also wanted to ask you a question about your comments on non-disclosure clauses and the inability to speak out and how that prevents systemic change. So I'm sort of interested in your submission, which sort of implies that this isn't the route to systemic change as it currently stands, bringing individual cases. It's about rights, but not systemic change.
Yes, I think that's right. As I said, much of the work that we do is invisible, and much of the work that our clients do in bringing complaints of discrimination is invisible. And that work is really, really hard. It takes a huge amount of energy to make a complaint of disability discrimination, and it can be an incredibly frustrating situation for clients to not be able to speak openly about that experience. And I think it's a real loss for the community not to be able to learn from that experience and improve on our culture in our workplaces by building on the lessons that have, been uncovered by those numerous situations that happen around Australia every day. So it is a loss. I should say not every person who experiences discrimination wants to speak, wants there to be public discussion or discourse about their experience. So I think we do need to be very careful about the solution to that problem. But currently, the culture among practitioners and conciliators and I think courts and tribunals and commissions is too far in favour of just accepting or promoting confidentiality terms as the norm or non-disclosure agreements as the norm.
And that relates to my final question, which is to both you and Ms. Wilson, that you both imply that there aren't significant visible consequences for employers, including even the size of settlements, that and also that reinstatement's not very likely, as Mr. Innes discussed this morning, that by the time you get to that stage, the relationship's pretty far gone. So that, the visible consequences to employers seem lacking. You both refer to that.
Yes, that's correct. And we have clients who achieve what legally, we would assess as a successful outcome, who feel that the consequences for the employer were not just and would not deter other employers from behaving in the same way.
Yes.
And that, to me, means that our laws aren't doing their job properly. They're not effective at preventing discrimination or really meaningfully changing employer behaviour. And that's particularly the case for our clients who are often on a lower income, and the compensation is tied to their earnings in most cases, because there'll be a component for lost income, past and future, and that will ordinarily be the bulk of the compensation claim. And that also is, I think, a terrible situation, that it's cheaper to discriminate against some workers than it is against others, and employers aren't paying the true cost of that discrimination.
Thank you.
Yes. Commissioner Ryan.
Just a couple of quick questions to Ms. Sligo. You used a term I'd not heard before, and it could just be my ignorance, but you referred to something called a shared burden of proof. I've not heard that expression before. Could you explain it to a non-lawyer like myself?
Yes, certainly. I don't think it's something I coined, but I don't know who did. So apologies for not being able to attribute that. My understanding of the meaning of that term is simply that both parties play a role in either proving or disproving that the discrimination occurred. So it initially is up to the person alleging the discrimination to demonstrate that that it occurred, and then the burden shifts to the employer to show that if there was that it didn't occur.
And the other technical question I wanted was with regard to the case you've made that there's an excessive level of use of confidentiality clauses. Could that, whilst I can see the argument you make for that, is it possible that confidentiality clauses are sometimes used as a bit of a bargaining chip to get employers to concede, and therefore, if it were to disappear altogether, there might in fact be more contention over claims, whereas sometimes employers will concede more readily because they won't be exposed to, they won't have public exposure. I mean, could there be an adverse impact for some people with disabilities making a claim if there was to be a limit on confidentiality? clauses.
I do share that concern that, and that's why I think the solution needs to be very carefully considered, because I think there is a risk that respondents will say, well, here's our offer of settlement with a confidentiality clause and here's our offer of settlement without, and you choose. But at the same time, at least that's an improvement on the current situation, because I don't think that's happening at the moment. I think that the sense that confidentiality terms are a given is so entrenched in legal culture at the moment that it's very difficult to even have a discussion about not including them. And I've had two conciliators in different jurisdictions say to me, that's just not how this is done. When I've said, well, hang on, we haven't agreed to a confidentiality term, the response has been, you know, we're not even going to go there.
Thank you. Thanks, Mr. Chair.
Mr. Oliveri, if any of the questions I'm about to ask you cause you any difficulty, you don't have to answer, but I'm just interested in some aspects of your case. Were you a member of a union at the time that you were dismissed?
No, I wasn't.
When the matter was resolved, was that done as the result of a hearing with a decision or the result of a mediation or conciliation?
Both, really. We had sit down for 3 days in VCAT, starting on the Wednesday, and then on the Friday morning, and there was one person from them to give evidence, and then they called my barrister in to make a settlement.
So it was settled in the course of the VCAT proceedings?
Yes, it was.
And was the outcome, I don't want to know anything about dollars, but was the outcome a payment of compensation of some kind to you?
Yes, it was.
But not any reinstatement, of course, to your previous position?
Never mentioned.
What's your understanding of why the employer either dismissed you or didn't return you to your job? What's your perception of it?
I believe that they didn't fully understand what had happened. I think they thought that I had a heart attack. And I think they never sort of went out of their way to find out, okay, I've now got a worker that's got a pacemaker involved. What precautions should I do? I believe that maybe there should be a bit of a hotline somewhere where employers can ring up and say, look, I've got a bloke that's just prolapsed 3 discs in his back. I haven't put him off. What are my options? What should I do? I just don't think there's anything in the system where somebody, like in my case, okay, he's had a dizzy spell, he's had a heart stop for a little while. Do I have any cause to worry? No, we're going to put a pacemaker in. He's got a pacemaker. He's better than he was before.
No, you're not attributing any malice on the part of the employer. Really, your view of what happened is that the employer just didn't understand your particular position and whether you were capable of doing the work.
Yeah, and look, in emails to and fro or text messages saying, look, I've had this done. My cardiologist actually spoke to my boss and explained to him exactly what was going down, and there would be, no long-term problems with me returning to work.
Thank you very much. That's very, very helpful. Thank you. I just want to make, and I'm sorry if I'm taking a bit of time, just want to make a comment. One of the characteristics of the law these days is specialisation, subspecialisation and sub-subspecialisation. I understand why, in the case of each of you, Ms Wilson and Ms Schleicher, you can only offer either advice or representation if the problem that comes to you can be characterised in a particular way. And I don't make any criticism of that, but I merely comment that that's one of the consequences of the degree of specialisation that we've come to in the law. It would be very much better if there were agencies that could actually address a problem and determine what the best approach to that problem, the person, what is best for that person, regardless of the pigeonhole into which it all falls. I only mention that because it's not confined to disability. It's a problem across the legal system that we now have, that specialisation has become so pervasive and so narrowly defined in many areas that we're moving away from solving a person's problem and moving towards categorising the problem and determining into which pigeonhole it falls. But you can take that for what it's worth. It's just an observation.
Chair, can I add that this is a matter that the Royal Commission will look at in its work with respect to access to the justice hearing. And one of the issues also relevant is the terms and conditions on which legal services are funded, and the extent to which the funding arrangement also at times restricts the types of matters that the legal services can take on.
I have had some modest familiarity with these issues over the decade. All right, well, thank you very much for coming to the Commission and giving evidence. We very much appreciate your assistance, and thank you particularly, Mr. Oliveri, for sharing your experiences. That's extremely helpful to us. Thank you, Ms. Wilson. Thank you, Ms. Strike.
Thank you.
Thank you, Chair. Now, we've run a little bit over time, but if we could adjourn for 15 minutes for afternoon tea, and then we'll return with the final session for today.
Yes, we'll resume. It's now 8 minutes past 3. If we resume at, is 3:25 too long? 3:25.
Royal Commission is resumed.
Yes, Ms. Bennett.
Thank you, Chair. This afternoon, we have Ms. Marcella, the CEO of Aboriginal Employment Strategy. Ms. Marcella, can you hear me?
Yes, I can. Thank you.
Thank you. Now, Commissioners, Ms. Marcella has not provided a statement, but a summary of her CV can be found at Bundle A, tab 1.
Yes, Ms. Marcella, thank you for your appearance at the Royal Commission and for your assistance that I'm sure you will give to the Royal Commission. Just to indicate where people are located, Commissioner Galbally is joining this hearing from Melbourne. I'm in the Sydney hearing room with Commissioner Ryan on my right, and Ms. Bennett will be asking you some questions also from the Sydney hearing room. And I will now ask Ms. Bennett to ask you some questions.
Thank you, Chair. Ms. Marcella, can I just start by asking you to tell us a little bit about your cultural background and where you're from?
Firstly, I just want to acknowledge that I'm on Gadigal country today and pay my respects to elders past, present and future. I'm an Aboriginal and South Sea Islander Murri with cultural connections to central Queensland, but I'm also part of the Aboriginal community of Sydney City.
And can you tell us about your current role?
Yes, I'm the CEO of the Aboriginal Employment Strategy, which is a national Aboriginal not-for-profit employment and group training company.
And can you briefly just tell the Commissioners a little bit about your professional history that might be relevant?
I've worked in Indigenous affairs for almost 30 years across New South Wales, Queensland and the Northern Territory. I guess I'm a generalist across the area of Aboriginal affairs in that I've worked across most portfolios in Aboriginal affairs. A particular focus on social justice, community development, and very pleased that I've been able to work in Aboriginal employment and training for the last 7 years.
Right, so tell the Commissioners a little bit about how your organisation works and what its function is.
Sure. So the AES is a government-funded service that's available to all Aboriginal people across the country. We're not an employment service that has a compulsion to engage with our service. It's a service that Aboriginal people engage in by choice. Our offices are staffed by local Aboriginal and Torres Strait Islander people and a very small number of non-Aboriginal people in the 16 locations that we operate.
And what are the kind of services that you provide to people who are your clients?
So anything employment related, from talking to people about career options to supporting interview preparation, resume preparation, addressing barriers to employment. And that can be all sorts of barriers, from unstable housing to leaving domestic violence, relationships, to supporting with childcare, to equipment, training, licensing, building confidence, you name it. Any barrier that a person might experience, we help support to address those barriers. And then we also provide ongoing support once a person is placed into employment. We provide mentoring and other types of life coaching for at least 6 months post-placement, and also providing support to the employer to make sure that placement is successful and positive for everybody.
So just to go back to the kinds of barriers that your clients often face, do they arise principally from health and housing issues that they bring with them to your service? Can you tell us a little bit about how they present to you?
Yeah, it's usually, as I said, our Aboriginal candidates come to the AES by choice. So we will know very little about a candidate when they present to an AES office. So we do spend quite a bit of time getting to know that candidate around their aspirations for a job or for a career, understanding them as a person, where they've come from, their family life, and their strengths, skills, in order to be able to find a really positive match for aspiration and skill set capability to a hopefully a really positive employer.
We've been talking a lot today about barriers for people with disability to employment. Is that something that features in the clients that present to you?
Absolutely. We work with all Aboriginal people. So, we work with Aboriginal young people, older people, women, men, Aboriginal people with disabilities. So whilst we're not a disability service provider per se, but we work with everybody in the community. So that does require a level of understanding around supporting Aboriginal people with disabilities. A lot of our clients, during our time in understanding who they are and their career aspirations, will actually disclose whether they have a disability. So we can understand what services they might be accessing outside of the AES, getting them to disclose to us are there any particular needs around that type of disability that they disclose to us. But we do spend some time also, a lot of our clients don't use the language of disability. So, for example, we will, through often long conversations and getting to know somebody, someone will disclose whether they've got particular mental health issues, what I've come to know as psychosocial disability, and often they won't use the language, like I said, of disability. So getting to know those types of barriers for that particular candidate, we will often refer them back to their GP or to the Aboriginal Medical Service to actually get them to have that conversation with a professional about that particular thing that they've disclosed to us, in order for them to identify and better understand what that issue is and access appropriate resources and services. But it also enables us to better service them to understand, I guess, what would be a good fit for a particular industry or employer.
And so is it fair that almost all of the clients that access your service, in addition to being Aboriginal or Torres Strait Islanders, often have an experience of what we would call disability, but perhaps is not necessarily identified in that way?
Yeah, absolutely. I guess we're not surprised by that, in that most Aboriginal people face multiple barriers. So we've become very good at supporting candidates with multiple barriers. So understanding them certainly helps support the candidate into a role and success in that role. But in the main, those conversations are more about their strengths and their asset, what they can do rather than what they can't do, and actually attempting to map out a pathway where it's about a career, not just a job.
All right, I'd like to come back to that proposition in a moment, about a career rather than a job. Before we do that, though, I just want to understand, how do you go about identifying recruitment opportunities for your clients?
Yeah. Typically, we work across every sector and industry, from small family-owned businesses to tier 1 companies and international companies. But we don't just work with anybody. We are quite particular in the types of employers that we work with. We want to make sure that they're on the same page as us around values. We've had some experience with employers approaching the AES, given the current climate of Aboriginal procurement targets in a lot of government contracts, where they'll come to us to source Aboriginal workers so they can tick the box. So we're quite mindful about, I guess, people's intentions around approaching AES. But generally, we've been around for 25 years now, so we've become very good at identifying employers who are genuine, who are inclusive, who are willing to work with us to actually design culturally appropriate, culturally sensitive, all-round inclusive employment practices. So we've got some really solid relationships with employers who are willing to do that. And then, so...
Can I ask, I'm sorry to interrupt, how do you distinguish between the box tickers and the ones who really want to walk the walk?
Again, it's about really spending time to know who we're working with or who we might work with.
Yes.
Those I've often had first conversations where, for example, a large corporation who have a very large diversity and inclusion team and have approached AES for support. But it became very clear early on in those conversations that they were experts in diversity and inclusion. But when I asked them how many Aboriginal people they had employed, the answer was, 1, maybe 2 Aboriginal people nationally. So I guess for me, I'm like, well, if you're experts, you don't need our help. But by virtue of only having 2 Aboriginal people across your company in Australia, is kind of proof's in the pudding, as I say. So you get to interrogate their approach, I suppose, about how they do things, whether they're willing to take a different approach. I often flip their recruitment practice on its head, and people will embrace that if they're actually genuine about being inclusive of everyone in our communities. Or if they're quite rigid in their approach, that is a very good indication that their company, their work culture is not going to be a welcoming, friendly, inclusive workplace for Aboriginal people or for others.
Well, so I'm interested in this notion of what you flip on their head. You ask them to flip their process on their head. Can you tell us a bit about what sort of changes have you asked to see from companies that to increase their level of inclusion?
So they will often have a certain type of interview approach, certain type of questioning, panel makeup, where the interviews are held, other type of interview process testing like psychometrics, who participates on those, how that's run. So often that with a lot of employers, there's a process mapped out, and they may or may not want to change that process. So we'll often recommend recruitment in certain, to change up the location where the interview occurs. We might encourage Aboriginal people as a group to go through an interview process together. So there's cultural safety, there's opportunities for Aboriginal candidates to provide peer support for each other. We will help redesign interview questions to make sure that they're designed and asked in a way that's going to provide the best responses from Aboriginal people.
Well, can I just pause there? So you actually, as part of your role, you actually engage with the HR department about what kinds of questions would be appropriate for particular clients to draw out their strengths. Is that right?
Correct. That's correct. Yep.
And is there any concern ever expressed that somehow is not going to provide an outcome that reflects the job that's on offer or something?
Yeah, or not fair and equitable for other participants who might be going through the same process. So, I often have debates around will Aboriginal people get an unfair advantage if we do it differently? So I kind of challenge them on that and saying that your current process is actually excluding Aboriginal people. So unless you do it differently, you're actually providing an unfair advantage to non-Aboriginal people through that process. So
can I reflect that back just to see if I understand it? The status quo of an interview process, for example, it seems that what you're saying is that produces a workforce that is overwhelmingly non-Aboriginal and non-disabled. Is that fair enough?
Yes, correct.
And that if you expect it to look any different, you need to change the way you go about those processes that led to that situation.
Absolutely.
And this is the conversation that you're having with those employers, and some of them are receptive to that. Is that right?
That's right. Yep.
And those ones are the ones that engage with you around how it can be done differently.
Absolutely. Yes.
Thank you. So is there resistance from employers about providing what we've been talking about as adjustments, but perhaps we don't need to be restrained by that language, about adjustments that people might need to the way that their workplace operates to accommodate them? Do you find there's resistance to that, or are people open to it?
I think there's usually some initial resistance, but the good employers will generally work with us on that. We intentionally build quite close relationships with potential candidates and employers. I think when people see the value of an individual and those personal relationships are built, I think people are more willing to accommodate any special requests, make any adjustments when they actually get an appreciation of the value add that person brings to the organisation. So I don't know, we're used to working with, again, because of the diversity in Aboriginal and Torres Strait Islander communities, we are extremely diverse. I guess we have been quite successful in getting employers to really embrace that difference in so many ways, whether it's, Aboriginal women who have disabilities themselves, but who are also critical carers of family members who also have disabilities, and the impact that has on their ability to work certain hours or requiring additional flexibility. So again, it's just about really interrogating organisations about, you've done it this way for so long, but, you know, if we change it to this way, is it really going to make a material difference to how the work is done? You know, creating everybody, we've seen it in the world of COVID, how people thought we could only do something one way, and yet COVID has flipped that on its head. So, you know, we've taken a similar approach around, okay, you know, you've done it this way and that's okay, but let's try something differently where people feel valued in your organisation. You're going to get more personal buy-in from the workers and their families. You're going to have greater retention and loyalty to your company by really providing a work culture, not just for Aboriginal people or Aboriginal people with disabilities, but for all your workers where they feel valued and included.
And have you... Sorry,
can I just ask a question?
Yes.
I'm a little unclear as to who the clients are that you're working with. Are you working with employers to make them better employers of people with who are Aboriginal, or are you working with individual First Nations people who are seeking jobs? I wasn't quite sure.
Both. Yes, so we actively work in identifying employers that we'd like to work with and provide Aboriginal candidates, but obviously we're working on the ground and across communities with Aboriginal people, unemployed Aboriginal people looking for employment. So we invest equal amounts of time in relationships with employers as we do with the Aboriginal candidates, and all sectors, private, public, local.
I just needed that. I wasn't quite
sure.
No,
that's okay.
I can follow this a bit better now.
Do you find that over time the attitudes of employers shift the more exposure they've had to your organisation and to the candidates you place with them?
Yes. And I'd be worried if we didn't. We wouldn't be very successful if we didn't. But yes, absolutely. So again, it's those relationships.
Yes.
And I do believe, whilst we work exclusively with Aboriginal and Torres Strait Islander people, I do believe that challenging employers to do things differently with the diverse Aboriginal and Torres Strait Islander candidates we have, I do believe has had a flow-on effect to other people outside of our community to get employers to think differently about their approaches to recruitment and also how they, their work cultures and their overall inclusiveness and support of other workers that they would employ also. So I'm quite proud of that we've been able to influence their approach.
And we were talking before about adjustments and about the way that a workplace might need to change after a person is engaged to work for them. Is there a time that you specifically start to raise those issues? Is it before the person is recruited, during the recruitment, or is it afterwards?
It can be all of the above.
Yes.
So if someone, we identify a particular barrier up front, we will, if there's a particular employer that we think would make a really great match for that candidate, we'll have some upfront conversations about whether an adjustment can be made. Usually, again, because of the relationships we have with employers, there is a high level of success in getting the employer to make that adjustment. Sometimes other barriers appear after someone has commenced employment, and because we provide mentoring support not only to the candidate but to also supervisors, we've had to, mitigate some of those and address those halfway through, or even on people's transition into other opportunities or to promotions. We've had to, be creative and help employers find some solutions if they think they've presented with the barrier. We just get them to open conversations about what could be an option, and even sometimes finding an even more positive solution to what we'd hoped for in the beginning.
Well, you speak about the ongoing mentoring. This is something I want to understand. So you assist a candidate for a job to find an employer that suits them.
Mm-hmm.
You assist them to engage with that employer in a way that allows them to showcase their strengths. And then when that employer engages them, you stay engaged with the candidate that you've placed. Is that right?
That's correct.
And you provide ongoing monitoring and mentoring. Is that right?
That's correct, yes.
Can you tell us about what is involved in that and the importance of that ongoing engagement?
Yeah, it's very much individualised. And it looks very differently for every candidate that we support. Some candidates require quite intensive support along that journey. Others, it might be just particular touch points through that, their employment, kind of check-ins that things are going okay. But often, if we've got an Aboriginal person who's got some particularly mental health issues, it's around maybe providing them with specialist Aboriginal counsellors to, often with, just helping them prepare and stay on track with what their GP or mental health professional has advised them. So just helping them keep on to that routine or advice that specialist has provided them to make sure that they can continue to engage in employment and that that's successful. So basically whatever it takes to support someone stay in a job, have a really positive experience, and keep that job long term so they can actually start to build a career.
Well, that's what I wanted to come back to. You talked earlier about not just a job, a career, and particularly from the perspective of people with a disability or who might face episodic challenges or ongoing challenges.
Mm-hmm.
Is there an expectation that do some employers have an expectation they'll just stay in the one job? Is that something you need to challenge?
Yeah, I mean, some candidates don't necessarily articulate career. They might say, I really just want to feel like I can contribute, that I can earn an income to support myself and my family, access, to buy a home or, if they've got children, give their kids the best of opportunities in the world. So some people are just wanting to work. And they won't often talk about careers and just want stability, certainty in employment, where others will certainly have aspirations to progress, and employers are really excited by that they can, I guess, build a pipeline of Aboriginal candidates coming through their organisation where they can continue to grow. They can develop pathways within their organisation for more Aboriginal people to progress. So there's certainly an interest in those corporate partners that we're working with to actually help facilitate that and showcase Aboriginal talent and the diversity that it is. So, yeah, absolutely, we've seen some great commitments from employers.
And do you have any sense of how long clients that you have placed remain in the jobs for? Do they have strong retention?
Yes. I'm not sure with others, but I know certainly AES, we're quite successful in the majority of Aboriginal people that we place into employment. A significant portion do not ever return to the world of unemployment, which is something we're very proud of. And, there's some statistics around that say if you can support a candidate to stay in employment for at least 6 months, every month after that, the likelihood of becoming unemployed continues to reduce at a significant rate. So certainly investing in that mentoring and other life supports and life coaching that we provide certainly delivers significant returns for our community and their families to reduce that sort of terrible cycle of unemployment in our communities that we have.
So you find it has a ripple effect both for the people around the candidate you place and the employer itself?
Yeah, absolutely. Yeah, absolutely. We see adults that we've supported into employment. It's been nice to sort of monitor that impact in sort of, I guess, very informal ways. We certainly don't keep data on how that affects families, but we have seen a bit of a trend where adults who have come from families where there's intergenerational unemployment, where they've been able to secure a job and hold it for over 12 months. The kids are doing better at school. There's greater engagement. They're talking about careers with their kids. So definitely seeing flow-on effects. And that, there's a certain level of cultural unsafety in a lot of industries and a lot of sectors. So the more Aboriginal people we can get employed, those are the organisations where there's a nice trickle flow-on effect for more Aboriginal people coming to that employer for work.
We've talked a lot today about overcoming the barriers that your clients often face, and I just want to summarise what I understand some of those barriers to be, to see if this is right. Is it fair to say that a lot of the candidates that you're placing into roles can face barriers that relate to unconscious bias, or what we've called attitudinal barriers? Is that fair?
Yes.
And they also face some structural barriers, like the intergenerational unemployment or difficulty getting to a workplace, getting the workplace to engage with them in a different way that showcases their strengths. Is that right?
That's correct.
And these are things we hear in this Royal Commission of a range of different contexts. So I just wonder if I can draw together what I understand to be the core of your organisation's approach. Is it fair to say that you engage closely with the person and with the organisation and try and draw them together in a person-focused way?
Yes.
What do you think is the best practice or the most the best practice to provide support and encouragement for people to overcome barriers of that kind?
For us, it's very much about trust and relationship.
Yes.
And many of us come with a whole lot of weakness, including myself. We focus constantly on our weaknesses and of what we can't do, then none of us would be in a job. So it's very much about identifying strengths, so a strengths-based approach, helping people identify what they are. Often we'll work with candidates who can't articulate what their strengths are, don't know what they're good at, don't know what industry they feel like they could be successful in. Again, it's that relationship in getting to know somebody and helping identify strengths and celebrating those, building confidence. And actually, like I said, building those relationships with employers where the candidate themselves can see that those strengths that they have are an asset. They're a valuable asset that an employer sees value in. So it's not about, I'm working with the AES, I'm Aboriginal and they're going to give me a job because I'm Aboriginal. It's about saying these are your strengths. And in the world of, world of Australian workforce, they are valuable assets. And that, it is this employer is actually lucky to have you as part of this team. And, let's celebrate those. And we all have weaknesses, but that doesn't, they don't define us, So it's often very much a strengths-based approach to how we work with candidates.
think in a discussion that we had before today, you said something like, if someone's recruiting for a box, we're very successful in giving them a triangle. Can you tell me what you mean by that?
I guess it kind of builds on the comments earlier around often recruiters, HR teams, so-called diversity and inclusion experts have this idea about what they think they want or what's going to work. And because it's usually no one's ever challenged them on that. I don't know how to really describe that really well, but it's, it's around, challenging them on these preconceived ideas about what's the perfect match or the perfect process. And we've surprised people on, when they wanted a box and we've given them a triangle. They've come back and said, you know what, we were wrong about that. And actually, this person that you referred to us has not only met all the requirements, but they've brought a very different element to the workplace. And we would never have typically recruited for that capability. And then actually now it's a key capability that we're going to start including now and looking for, because we've seen the positive impact it's had on our work culture.
All right. And can I just ask you about your success in general? So feel free to beat your own drum now. Your organisation's been a reasonably successful one. Can you tell the commissioners about how you measure that success?
I guess the secret recipe of success is around relationships and trust and a strength-based approach. That's the secret recipe for AS. How we measure it, that's very easy. I guess the fact that Aboriginal and Torres Strait Islander people continue to come to our service by choice, the repeat business, the engagement we get by communities, that's a measure of success. The fact that we support over 1,000 Aboriginal and Torres Strait Islander people into employment each year, over 150 young Aboriginal and Torres Strait Islander people into traineeships and apprenticeships. We've got one of the highest national retention rates post 26 weeks in the country. And we work with a lot of candidates who aren't job ready, and sometimes that takes a month or many months to actually get somebody job ready, and that takes a significant amount of resources, and we do our best to be able to do that. A lot of people have been written off, counted out, and we don't give up on our community. We work with everybody, and if that means taking a little bit longer with somebody, then that's what we do. And those successes, when you see somebody who, there was a case where an Aboriginal man with a disability, he was 45 and never ever had a job. And we worked with one of our really great supportive employers to actually create a position just for him. And, we met his mum, and she was crying with joy how proud she was to see her son for the first time in his life have a job where he felt valued, he could contribute to the family. Also took a lot of pressure off the mum in having to support him, and now he was the one supporting the family. So there's, loads of wonderful success stories when you just don't write people off. Everyone has something quite unique to bring, and it's about identifying those and celebrating that with everybody.
Ms. Marcella, thank you for your evidence. I'm going to ask the commissioners if they have any questions.
Yes, thank you very much. Commissioner Galbally, do you have any questions?
Thank you so much for your evidence. No questions, thank you.
Thank you. Commissioner Ryan.
Yeah, just a couple. I'd just like a little bit of information about your organisation. I take it you're an employment service. Are you specifically a disability employment service or a general employment service?
We're an Aboriginal and Torres Strait Islander employment service.
Right. So you're funded, I imagine, by DSS to assist people find jobs, eh?
We're funded by the National Indigenous Australians Agency.
Right.
Yes.
So it's a special category. Now, the other thing I just wanted to ask about, you were talking about you are a bit choosy about the employers you choose to work with, and you sort of say, unless they have our values and so on of that nature. Can I say that it seems to be that, is it because you're able to be choosy about the employers that you work with? That sounds like you have a lot of people wanting to work with you, which I don't think is the experience of people with disability, but is that true?
We've certainly got employers that fit into the category of, we've selected them by choice, but maybe there's certainly employers that are new on the block too, Commissioner, as well, so who we don't have a proven track record with. But I guess we engage with them and make a commitment to work alongside of them. Certainly in the world at the moment, there's significant shortages in workforce around the country because of COVID. We're seen as a solution to their challenge. So I guess we do it as a condition of working with us. Sometimes they do it terribly too, though, Commissioner, and sometimes they do it well. So we also don't count out employers also. So they make mistakes, they get it wrong. We will invest in building those relationships, doing the education, where we have to be as equally flexible as we ask them to be in our approach as well. And then, most people in the world are good people, and people are willing to make, do things differently. Sometimes it takes a little bit longer by our investment in getting it right. For example, if we're working in a small community where there are limited jobs, we don't have the luxury of choice to say, well, there's one employer in town with jobs going. How are we going to make it work? We don't say we don't like them because they don't have the same values. We're like, right, what can we do to actually work with them, find some common ground, find some key elements that we do see in common, and continue to influence, educate, and to make us feel confident that if we place someone with that employer, that's going to be not only a culturally safe, but a supportive, inclusive environment for candidates.
The reason I asked you about the environment you're working in, is it possible that there's something that, generally speaking, there is a perception that finding employment for Aboriginal people is difficult, as it is with people with disabilities. Mm-hmm. Is there something working more recently for people who are First Nations people that we could possibly apply to the employment of people with disabilities? You mentioned, for example, some companies come to you because of procurement requirements and so on. Is that, for example, an example of a program that's working well for Aboriginal people that might just as easily be applied to people with disability to assist disability employment services have the kind of environment that you have to work in?
Yeah, good point. There's definitely been some significant positives with that approach, but there's also been there's a lot of risk with that approach as well. Trying to think of an example that I can give you. People will employ, on the basis of that procurement policy, people will employ Aboriginal people for a week and then lay them off. They'll count them as a number against that policy. So actually it can be quite harmful to Aboriginal people if it's done the wrong way. And I think that's a risk for anybody who comes under a special measure type of approach. The good thing is, though, in that government procurement policies, there are targets for women, targets with people from that local community. There's people who return servicemen and women are included in those. it's actually quite diverse in what the New South Wales government's actually requesting of companies who are securing government contracts. So it's much broader than Aboriginal people, thankfully. What we love to do is provide them with Aboriginal people, Aboriginal women with disabilities, Aboriginal women with disabilities from that local community. So we certainly, like I said, our communities are diverse. We're not just Aboriginal people. We also are young people, we're women, we're people with disabilities, we're people with non-English speaking backgrounds. So we're quite diverse in that, but there is, Commissioner, so the answer is yes, there is benefit in that. And again, but there's some risk also.
Thank you very much. Thank you, Mr. Chairman.
Thank you very much. I assume that none of the represented parties wish to ask Ms. Masella any questions. And on that assumption, I shall thank you, Ms. Masella, for coming to the Royal Commission, giving your evidence today. We very much appreciate the assistance that you have provided. Thank you.
My pleasure. Thank you very much.
Thank you. Now, Ms. Bennett, are you going to tender some documents?
I am, Chair. There are a number of documents from today. If I could go through them in order and with a proposed exhibit number, would that be the most convenient?
Yes, I take it they're the documents that are recorded on this bit of paper. But
They are.
Yes. All right. Well, why don't you go through them and then I shall do whatever I'm told to do.
Thank you, Chair. There is the statement of Graham Innes, AM, dated 30 June 2021, and his attached curriculum vitae, and we ascribe those exhibit number 19-1 and 19-1.1 respectively. There's then the statement of Robin Banks and the attached curriculum vitae, which we propose to be 19-2 and 19-2.1 respectively. There's then the statement of Ms. Schleiger, which we tender as exhibit 19-3. The statement of Kirsten Wilson, which we propose to be exhibit 19-4, and the biography of Ms. Masella, which we propose to be marked exhibit 19-5.
Yes, thank you. All of those documents will be admitted into evidence and given the markings that you have indicated. Thank you.
Please, the Chair.
Now, I take it that concludes us for today. Is that right?
It does, Chair, yes.
Do either you or Ms. Eastman wish to foreshadow what will be happening tomorrow so that people who are following these proceedings eagerly will know what is to occur?
Yes, Chair. The morning will commence at 10 a.m. with a panel comprising the Australian Council of Trade Unions and a representative of the CEPSU to give some evidence around those issues at 10 a.m.
Yes, that takes us up to.
Yes, and then the Commission will be hearing from Ms. Jennifer Westacott from the Business Council of Australia before the lunch adjournment. After that, there'll be a panel on recruitment, from which the Commission will hear from a panel of employers, Australian employers, Kmart, Woolworths and Compass. And after lunch, the Commission will hear about recruitment perspectives, including positive neurodiverse employment practices, and we'll be hearing from IBM, Telstra and Services Australia. And that will be the day tomorrow.
Very good. Thank you. In that case, we shall adjourn until 10 a.m. Australian Eastern Summer Time tomorrow.
Please, Commissioner.
The Royal Commission is adjourned.